Savitramana. E3. Then who's Bharati? Bharati.
Bharati is also the wife of second wife's son's daughter.
Yaru? Rangegoda. Correct. So that it is. Nimballu Savitramana hakila. Savitramana hakila, Bharati no hakila. The first one, basic family relationship. No, that I understand. I just want to know who Savitrama and Bharati are. Are they the children of the first wife?
No, second wife.
Both of them.
The first son now.
Savitrama. Show it to him first. So fundamentally, the second wife's first son, second wife's second son, and first son's two daughters are the plaintiffs. And the defendants are the first wife's son, Nanjappa.
First wife's son, first wife's second son, and the third son.
Nanjappa.
Sannappa and Nanjappa.
Nanjappa is the defendant. D2.
Nanjappa Singappa.
Channappa
is defendant number 1. First wife's son.
Then who's D3? Rangegoda, son of Kalegoda. Who's D3?
D3 is the second wife's son. First, Kalegoda.
Allow first plaintiff on valid new.
There are two suits. I just come to this.
No, I'll go by OS2 per 2006 first. Because that is the first suit.
2006, Rangegoda, the first son, and Nanjappa, the second son.
Are the first and second plaintiffs.
They are the first and second plaintiffs.
Then Rangegoda's two daughters. Savitrama and Bharati are the plaintiffs number 3 and 4.
Yes.
Defendant number 1 is Chinnappa. Channappa, the first son of the first wife.
Second, first one is the daughter, the first son of the first wife.
Then D2 is Singamma, who is the wife of Nanjappa. She is D2. Then who is this Kalegoda alias Puttappa?
Because Kalegoda alias Puttappa has been made as party, who is the third son of second one.
Our plaintiff for
one case our plaintiff for
Kalegoda.
Kalegoda. OS 17 got.
He is the third son of the second wife.
Third son of the second wife.
Who is D4 Shantamma?
Shantamma
is ರಂಗೇಗೌಡನ್ಗೆ ಇಬ್ರು ಹೆಂಡ್ತೀರಾ?
ರಂಗೇಗೌಡನಿಗೆ ಇಬ್ರು ಹೆಂಡ್ತಿ, ಪುಟ್ಟಮ್ಮ ಶಾಂತಮ್ಮ.
ಯಶೋದಮ್ಮ ಯಾರು? Who's ಯಶೋದಮ್ಮ?
Yashodhamma is Puttamma's daughter. First wife.
Week 5. Manjula?
Manjula is also comes under the second wife.
Correct ಆಗಿ ಹೇಳಿ ನೀವು ದೀಪಕ್. ಸುಮ್ಮನೆ ನಾನು. What is your genealogical tree? Madam. That is Singamma. No. He is not able to tell me who this D6 is. Manjula, Kapanigoda, Swami, Ashok. Who are they? How are they related to the family?
They are the children of Yashodhamma, my lord. The first, Rangegowda had 2 wives, Puttamma and Shantamma. Puttamma had 4 children, Ratnamma, Yashodhamma, Savitramma and Bharati. Bharati. And Yashodhamma's children are Manjula, Kampaningegowda, Swami, Ashok.
Agatha, I don't think so.
Puttamma's grandchildren.
They are Puttamma's grandchildren, my lord.
Yashodhamma is aged 45 years. And her daughter Manjula is aged 30 years.
Yashodhamma is aged 55 years, my lord.
Correct, Anil. If you say something wrong on facts.
My lord, I have also filed a cross appeal in this matter, my lord. As per my instructions, Yashodhamma is aged 55 years, my lord.
I will take it that Yashodhamma's daughter is Manjula.
Please, my lord.
T6. Then who's Kapanigoda? Son of Vishakantegoda. Are there purchases in D7, D15 and D10? And who's Kapanigoda, son of Vishakantegoda? Because there is no mention of any Vishakantegoda in your genealogical tree.
Admitted practice, all children and Jannapa's children. And my lord Singamma, Anjapa's. The rest of the respondents all under the degree of parliament. My lords, here, both the plaintiffs are the children of second victim in both the suits. And they were claiming the similar properties under 2 partitions. Under these circumstances, OS number 2, my lords, OS number 70, both the suits were clubbed as there being a common plaintiff, common defendants, and also the suits were in competition. And the suit came to be dismissed. I thought the contention was this. There were certain properties which were purchased in the name of.
OS 2/2006 was filed by the first 2 sons. OS 17 was filed by the third son.
That is admitted fact, and the family tree is also admitted insofar as other legal heirs were expected. My lords, the suit came to be dismissed on this reason, stating that, my lords, there were certain properties which were purchased in the village called building in Chennai. Those properties were purchased in the name of the second wife, Puttamma, who she called her second.
Kadamma.
Under these circumstances, my lord, the scheduled items which were mentioned in both the partition suits claimed to be was held that this belongs to first wife's children, that is Channappa and Nandu.
So it was purchased in the name of Kadamma.
No. The shoot, the alternative properties were not part of the pension properties in both the suits. The properties which were standing in the name of Channappa that is the first wife's son. Those properties were called in question for partition. In both the sons.
Channappa admittedly claimed the property from Busi Kalegoda only.
Please, even that is happening.
It is a separate property.
Yes.
When did Busi Kalegoda die? 10/6/1970.
Please.
On his death, automatically all his children get an equal share.
Please, my lords. The contention was this. Under these circumstances, there were certain properties which were purchased in the name of second wife in unfriendly village. They are not part of the main scheduled property.
Did you raise a counterclaim?
Yeah, that was raised, that was the contention. Under these circumstances, my lords, the honorable trial court came to the conclusion that there is a partition and the properties which were purchased in the name of Kanamma, were under these circumstances, having purchased the properties in the name of Kanamma, these properties have fallen to the share of the first wife. The properties which were purchased in the name of second wife Kanamma have fallen to the share of second wife's children. This was the foreign partition which has been understood between the parties. And with respect to those issues were framed. Under these circumstances, my lord, once the trial court was dismissed and RA was filed. Even RA, the common judgment was passed. In RA, the contention which was raised and the court arrived at a conclusion so far as section 14 of Women's Right to Property Act. Having purchased the property in the name of second wife Kalama, that becomes a absolute property. Under these circumstances.
So your counterclaim was also dismissed by the trial court?
Yes.
You did not challenge that?
No, I did not challenge.
So that is, those two properties are out of the dispute now.
Yes.
So all that remains is,
Properties became her properties. So under these circumstances, my lords, I filed an appeal in second appeal here.
no, now the appellate court has held, since it is property of Busi Kalegoda, everybody had a share.
Everybody has.
What is wrong?
Now, my lords, I have filed an appeal. In this appeal, my lords, that is the legal heirs to come under the tree of Kanamma. Other than the other Bharati, Yashoda, all these children, my lord. They have also executed, the list is pending, my lord, a registered release deed in favor of Channappa's legal heirs.
All of them, all the plaintiffs, who has executed?
Everybody except the third son, that is Nalegoda alias Puttappa.
So you are saying now Ragegoda, first plaintiff,
Everybody.
Nanjappa, Savitramma and Bharati have given up.
Yes,
So there is-
except Nalegoda alias Puttappa.
So so their share will come to you.
Yes.
You only have to give the share to Kalegoda alias Puttappa.
The only share in so far as what has been left out is Nalegoda and alias Puttappa.
ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ, ಮಿಕ್ಕಿದ್ ಸಿಕ್ತಲ್ಲ ನಮ್ಗೆ. You can't deny this. How can you deny this?
There was an understanding as the papers did not meet, they are unable to establish that they are not the properties of Kanamma, absolute properties of Kanamma. So under these circumstances, my lords, all this started when the first plaintiff, when this opponent, that is the first five children, wanted to develop the property, that is the only property.
ಆಯ್ತಲ್ಲ ಅದೆಲ್ಲ ಬಿಡಿ. ಇವಾಗ
ಅದಕ್ಕೋಸ್ಕರ ಇದೆಲ್ಲ.
ಇವ್ರೆಲ್ಲರೂ ಕೊಂಡ್ಕೊಂಡಿದ್ದೀರಾ, ಅವನೊಬ್ಬನ ಆಗ್ಲಿಲ್ಲ.
ಎಷ್ಟಿದೆ? ಅವರು ಅದನ್ನ release deed ಅಲ್ಲಿ ಹೇಳೋದು, they don't see
ಎಷ್ಟಿದೆ ಪ್ರಾಪರ್ಟಿ?
property is in general.
ಅಲ್ಲ, ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ 2 ಎಕರೆ 12 ಗುಂಟೆ, ಆಮೇಲೆ ಒಂದು ಮನೆ and one house. How much will you get? How much will you get? Why are you fighting? Channappa 1 ಭಾಗ, ಸಿಂಗಮ್ಮನ್ 2 ಭಾಗ, 3, 4, 5 ಭಾಗ. 20 ಗುಂಟೆನೂ ಬರಲ್ಲ ಅಂತ ಕನ್ಸ. ಮತ್ತೆ 20 ಗುಂಟೆಗೆ ಯಾಕೆ ಜಗಳ ಆಡ್ತಿದಾರ? ಇದಂತೂ ಬಂತಲ್ಲ, ಪೂರ್ತಿ ಬಂತಲ್ಲ ನಿಮ್ಗೆ, ಇನ್ನೇನಕ್ಕೆ? ಆಯ್ತಲ್ಲ, ನೀವು ಅಪೀಲ್ ಹಾಕ್ಲಿಲ್ವಲ್ಲ? But you should have filed an appeal. Should have filed an appeal. Without the appeal, what can you do? How can you bring that in now, having not challenged it in appeal?
Now that is the second appeal which is filed by your, I came to the other.
No, you said you had filed a counterclaim in the trial court. Counterclaim was dismissed.
No, they told, my lord, sir, insofar as unfriendly properties, a conclusion was arrived.
Did you or did you not raise a counterclaim? No.
No, my lord, it was not.
So therefore-
a counterclaim, it was a defense which was.
So therefore, that defense has now been overruled.
No, the defense, now in RA, the defense has been overruled. The defense in RA which has been overruled is to be considered by this court.
What is your answer? What is your answer to section 14 if she has purchased in her name?
My lord, sir, because section 14 says that any property which is purchased in the name of the woman, that becomes an absolute property. And there is also certain exceptions to that.
But both these appeals were filed by the plaintiffs only. You did not file any appeal. Again, did you raise a cross objection in the appeal that the finding is bad?
No, I did not.
ಬಿಡಿ ಇನ್ನೇನು
ಅದಕ್ಕೋಸ್ಕರ ಒಂದು ಗೋಪಾಲದ ಏನಾದ್ರು
ಒಪ್ಪಂಗೆ
only dispute is in the so it needs to be compensated.
You give her a figure right now. ಆ ಲೋಕದಲ್ಲಿ ಹೋಗ್ಬಿಡ್ತೀರಿ ಅಷ್ಟೇ ತಾನೇ ಆಗೋದು. ಅದೇ ಎಷ್ಟು ಅಂತ ಹೇಳಿ ನೀವು ಎಷ್ಟು ಅಂತ ಹೇಳಿ ಅವ್ರನ್ನ ಕೇಳ್ತೀನಿ, ಅವ್ರು ಒಪ್ಕೊಂಡ್ರೆ ಆಯ್ತು. ಇಲ್ಲಾಂದ್ರೆ she'll get 20 guntas of land in some corner which she'll get another 7 years for her to get that 20 guntas. ಅಲ್ಲ ನೀವ್ ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಅಷ್ಟು ಹೇಳಿ ಸಾಕು. ಆಮೇಲೆ ನನ್ನ ಪ್ರಕಾರ I don't think you have a case. There's no point in keeping this pending. On what? Only if you admit that the property was purchased by Pusi Kalegoda and died in 1970. Succession opened way back in 1970 itself.
But the oral partition was proved before it.
That is now gone.
Gone in an higher appeal.
And your oral partition is based on the sale deed. Finding of fact, I can't really interfere. 20 ಗುಂಟೆಗೆ ಎಷ್ಟು ಜಮೀನು ಎಷ್ಟು ಕಾಸು ಕೊಡ್ತಾರೆ ಕೇಳಿ, ನೀವು ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಹತ್ರ ಕೊಟ್ಟರೆ ಅವ್ರು ಒಪ್ಕೊಳ್ತಾರೆ. ಇಲ್ಲಾಂದ್ರೆ you'll get an order of dismissal. You have to share, isn't it? It is not your property. I understand your difficulty that they have a larger share, but your father should have been a bit careful. The second wife was more affectionate towards him. Probably that's why he's given. Okay, 20 ಗುಂಟೆ ಕೊಟ್ಟು ಮುಗಿಸಿ ಯಾಕೆ ಅದಕ್ಕೆ ಮಾಡ್ಕೊಡ್ತಾರೆ. I don't think they'll become crorepati's by 20 guntas. No, I will make an observation that if the plaintiff number 1, 2, 3 and 4 have released their share in your favor, in the FDP their share will be allotted to you. They are symmetric. As far as Kalegoda is concerned, you'll have to give him the 20 guntas of land. It's better that you give 20 guntas right now or pay the value and buy peace. Something alla. ನೀವು ಅದಕ್ಕೆ ಆಫರ್ ಕೊಡಿ, ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ತಾರೆ. You appear for Kalegoda alias Puttappa.
I appear for Singama, my lord, with the defendant number 2 in OS 206. I filed an appeal challenging the oral partition between the second son and the fourth son, third son and the fourth son of first
Give me
wife,
their names.
Channappa and Singappa, Anjappa.
It is between your husband and.
Please, my lord. Please, my lord. Allegedly, there is a partition deed which has taken into place between Channappa and Singama, but that is unstamped and not properly executed document.
That has been verified. There was a partition deed which was entered between.
Under this decree of the appellate court, all of you get a share. You will get one share. Kalegoda alias Puttappa will get one share. That is all. Why? What is the point?
Learned appellate court has held that the partition deed which is at exhibit D86 is not admits the partition deed which has taken between Channappa and Singama. If that document itself is admitted, my right to the property is nullified, my lord, because in the alleged.
Have they refused a share? Does the appellate court refuse a share?
Channappa, who's the appellant here, has my submission is my lord, exhibit 86, which is relied by the Learned Appellate Court to say that there is already a partition between the family.
This is a registered partition between you. Come to page number 65. You said it's unregistered.
It is registered. It is the contents of the document show that it's a release deed. However, the document is nomenclatured as a partition deed. Proper stamp duty has not been paid, and we have not received the 1,40,000 which is allegedly have been given to us in the partition deed, my lord. We dispute the deed itself. That cannot be relied on.
What was your defense in the trial court?
My lord, I was not represented before the trial court and the appellate court. For the first time, I am appearing before this honorable
Is it
court.
permissible for you to now in
My
second
lord.
appeal filed by them?
My lord, I was not represented, my lord. I am an illiterate woman, rustic lady. I may be given an opportunity to prove that this document cannot be relied upon to show that we don't have any rights in the property, my lord.
I will hold it against you. It's a registered partition deed. Can that be invalidated on the ground that money is
My
not
lord,
paid?
my lord, my humble submission is I have filed a separate appeal challenging the partition. Let the matter be listed. I will urge all the grounds which is necessary to show that the exhibit D86 cannot be relied upon to admit the partition between the families.
Post RSA. What's the number?
FR number 1060 of 2020, my lord.
It will go on delay only.
My lord,
It will go on delay. You file the second appeal after 4 years.
my lord,
Post
in 2020.
RSA
FR 1060 of 2020, my lord.
day after tomorrow. By that time, you gave them an offer. Who appears for this Kalegoda alias Putappa? Who's R for me? Kalegoda alias Putappa. You will get, I think, according to my calculation, about 20 guntas. If he is prepared to pay you the value of 20 guntas, take the money and close it. Day after tomorrow. Your appeal will go on delay.
My lord, I will make my submission on.
No, I forewarned you.
Please, my lord. Thanks.
Wednesday. Thursday.
Case I appeal for the sixth respondent. He died on 7/1/2018, Your Worship.
Six respondents.
Sixth died on 7/1/2018.
Sixth respondent.
With the seventh defendant in the trial court.
I noticed only about the first respondent's death, my lord, that if it is there, that I will.
Sixth respondent is Krishnappa.
Krishnappa.
Was he represented in the trial court?
Yes, my learned friend himself has represented him.
They submitted that R6. Passed away on?
The date of death.
Rajagopal ಅವರೇ ಯಾವತ್ತಿರೋದ್ರು?
7/1/2018.
7/1.
2018.
I will.
Since no steps have been taken, the appeal as against R6 stands abated. Application ಹಾಕಿ ನೀವು ಹಂಗಾರೆ.
I will file the application.
For this next Thursday, next Monday.
God bless.
Shivram. Shivram. Next Monday. Intermodal W shall stand extended. Next day.
I pay for the appellate in this matter.
Yes.
Suit for injunction filed by the plaintiffs. Plaintiffs are the appellants before your lordship. Now, the suit schedule property is one revenue site which was formed in a layout called Mahadevpura Extension. Admitted facts of the case are that the land in survey number 149/2B, measuring 19 guntas,
19 guntas.
was original 19 guntas of this Mahadevpura village, Kasba Hobli, Mysore Taluk. This was originally belonged to the father of respondent, husband of respondent number 1. And
ನೀವು ಕೇಳಿಸ್ತಲ್ಲ ಮಾತಾಡೋದು. I can't hear you.
I'm sorry, madam.
ವಾಲ್ಯೂಮ್ ಏನೋ ಕಮ್ಮಿ ಆಗ್ಬಿಡುತ್ತೆ.
Am I audible, my lord, now?
ತುಂಬಾ ಕಮ್ಮಿ, weak, feeble.
Okay. Now, my lord, is it better?
No better.
Better?
Yes, yes, yes.
Yes, I'm sorry. The second appeal is arising out of a suit for permanent injunction filed by the appellants. The property in question is a revenue site, which is part of a layout formed in survey number 149/2B, measuring 19 guntas situated in Mahadevpura village of Mysore Taluk. This particular property admittedly belonging to the husband of respondent number 1 and father of respondent number 2, Madhegowda. Admittedly,
Husband of?
yes, my husband of respondent number 1 and father of respondent number 2.
Yes.
Admittedly, admittedly sites have been formed in this particular land. That is the case put forth by the respondent.
You purchased the site from Madhegoda?
So what happened is this: my client's, that is my client's mother, by name Kalamma, she had purchased this property under an unregistered sale deed dated
Registered sale.
unregistered sale deed dated 15/4/1991 from one Ramu. Mother of the appellant had purchased it. This
Who was Ramu?
Ramu had in turn purchased the property from the father of the Madhegowda, the predecessor writing of respondents 1 and 2. And the sale deed was executed by this Madhegowda along with his wife and other children. Even
On?
that was
On
on
date.
12/2/1982.
12 to?
1982. Unfortunately, this sale deed also was an unregistered sale deed.
ಮತ್ತೇನ್ ಮಾಡೋದು?
But ಆಮೇಲೆ ಏನಾಗಿದೆ, see, Kata was made in her name. My only submission is this: I have to put it in a nutshell. Documents were produced by my clients before the trial court to indicate that they are in possession of the property. Kata extract and the tax demand register extracts, tax paid.
It is a vacant site?
It's a house property. We claimed that she's in owner in possession. She's in possession of site number 7. Whereas they have produced documents pertaining to some other site. And those documents are the documents which have come into existence during the pendency of the suit. Trial, both the courts below have dismissed the suit for permanent injunction on the ground that there is no title to it. According to that particular
Title is one thing.
title is one
If it is a house property,
yes.
Did you produce any electricity bills or any other?
We have
document
produced this Panchayat certificate exhibit P8, tax demand register of the Panchayat to indicate that they are in physical possession of the property.
No,
And
if
what
you're-
has happened?
If you are residing there right from 1991, you should have a voter list, Aadhaar card, electricity bills, telephone bills.
The documents which have been produced are these documents, exhibits P5 to P8. They have come into existence earlier to the filing of the suit only. As on the date of the
Their
filing,
demand is to extract, to show physical possession. They don't admit your possession, isn't it?
they don't, what they are making is, they are making a claim in respect of a different site number.
Maybe so. Let them claim whatever they want. I'm just
They may
trying
not
to
admit,
show
they don't
possession.
admit my possession. But at the same time, these were the documents which were produced by me. The documents produced by them are the documents which are pertaining to another property and which have come into existence during the pendency of the suit.
But by default, can we hold that you are in possession?
What I am submitting is this: the entire approach of the courts below is that some photographs are produced. Can this be an approach? Is my respectful submission. Some photographs are produced wherein they have these respondents, they have taken a photo in front of the property. Those photographs are confronted to us.
I'm not going by what they have done. I'm only concerned with what you have
Submitting. What I am submitting is both the courts have dismissed my suit not by appreciating my documents. What they have done is, the only approach on which the suit has been dismissed is, I don't have title. And first appellate court judgment is
that is a fact that you have no title. I'm only concerned as to your physical possession.
physical possession.
For that, apart from the tax demand extract, since you're claiming it as a house,
Gram
what have
Panchayat
you-
certificate is given. Gram Panchayat certificate has been produced.
ನೀವು electric bill ಇರ್ಬೇಕು ತಾನೆ ನಿಮ್ಮ ಮನೆಯಲ್ಲಿ
Electricity bill produce ಮಾಡಿರ್ಲಿಲ್ಲ, ಅದು ಒಪ್ಕೊಳ್ತೀನಿ. But what I am submitting is, apart from electricity bill, can that be the only approach?
that can be the safe evidence for me to come to the conclusion that you are in possession.
Now, my only submission is this: if there are any documents relating to electricity connection, I will certainly produce. They were not produced before the courts below. But now I have produced the documents. There are unregistered documents which have been executed at an undisputed point of time. Sale deeds are there, which in fact I have, along with my additional evidence application, I have produced. First of all, let's
Come to page 36.
36 of
The trial court, page number 15.
Internal page number 50. May I read Miller? Para 18.
Just above para 18.
Yes, kindly see. Even PW2 has admitted that she has not put in to show that she is residing in the said house. PW2, that is right from 1991. That's what they are asking.
Maybe as further admitted.
Suggestion was from 1991. You money so they have you got any documents?
Next sentence note.
PW2
has further admitted that defendants have taken
electricity
connection to the said house.
What is happening is this. This is defendants have put forth a connect. May read the evidence of PW2. Kindly see the evidence of PW2. It is a case of misreading of evidence is my respectful submission. PW2's evidence. In fact, defendants are making a claim in respect of property bearing number 555. They have produced documents pertaining to site number 9, whereas site number 7 is the suit schedule property.
Electric bills, I am swayed by electric bills.
Electricity.
It indicates, and your admission that they have obtained this connection, I think.
No, my respectful submission would be that there is a total non-consideration of the materials by both.
Connection.
You ಬಂದು photo ತೆಗೆಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಅವ್ರ ಮನೆ ಮುಂದೆ ನಿಂತ್ಕೊಂಡು ನಾವು ಇಲ್ದೇ ಇರೋ photo ತೆಗೆಸ್ಕೊಂಡ್ಬಿಟ್ಟು if that those photographs can be the ultimate evidence for deciding the case.
No, I am not on photographs at all. If you had produced electricity bills to show that you are residing there, and it is not a small.
No, I will read the cross-examination of PW2 for a minute.
Suit is of the year 2010.
How?
You claim to have purchased the property in 1991.
How?
For a period of 9 years. You should have some documents to show that you are actually residing there.
9 years under what has happened is we have, as on the date of the filing of the suit, I am supposed to produce documents in respect of a suit for injunction.
Even corresponding documents both sides.
Yes, Miller. I will read the cross-examination of PW2. How it has been misread on the hello. May I submit you? May I read this one? ಸ್ವತ್ತಿನ ದಾಖಲೆಗಳು ಪ್ರತಿವಾದ ಹೆಸರಲ್ಲಿ ಇದೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ದಾವಾ ಸ್ವತ್ತಿನಲ್ಲಿ ಎರಡೇ ಪ್ರತಿವಾದಿ ಮನೆಯನ್ನು ಕಟ್ಟಿರುತ್ತಾರೆ ಅಂದ್ರೆ ಸರಿಯಿಲ್ಲ. ಪ್ರತಿವಾದಿ 2010ನೇ ಇಸ್ವಿಯಲ್ಲಿ ದಾವಾ ಸ್ವತ್ತಿನಲ್ಲಿ ಇರುವ ಮನೆಗೆ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಪಡ್ಕೊಂಡಿರುತ್ತಾರೆ ಅಂದರೆ ಸಾಕ್ಷಿಯು ಸುಳ್ಳಾಗಿ ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ ಎಂದು ಉತ್ತರಿಸಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ದ ಎವಿಡೆನ್ಸ್. ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ kindly let me read this. Only 2 minutes. I will not take beyond that. ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ what is it? ದಾವಾ ಸ್ವತ್ತಿನಲ್ಲಿ ಪ್ರತಿವಾದಿ ಬೋರ್ವೆಲ್ ತೆಗೆಸಿರುತ್ತಾರೆ. Nobody's case that there is a borewell. What I am submitting is the defendants have come out with such a case where if at all, if the evidence of DW2 is considered, DW1 is considered rather, it is very clear that they are trying to suppress the material facts. They say that it's an agricultural land. They say that the lands, the crops are being grown. At the same time, they also admit that revenue sites are there. At an undisputed point of time, there are unregistered sale deed of 1991. So I mean 1982.
Undisputed
we can't expect them to admit it. But
in an injunction suit, in such a case, there should be some positive evidence. I can't really.
No, my only respectful submission would be the exhibit whatever ultimately preponderance of positive in a civil litigation. I have produced.
Not in this case, Mr. Rao. Not in this case.
My only submission is kindly see the first appellate court judgment for a while. That is totally contrary to the law laid down by the Honorable Supreme Court in several cases. There is
conclusion sari ide alva.
Conclusion sari ide andre should they not? First appellate court is the court of facts. We have produced additional evidence. Kindly see the evidence. Not even 5 pages judgment. Kindly see the first appellate court judgment. Can this be the manner in which the first appellate court can discharge its duties? Is my respectful submission. Now, this is beyond this.
Photographs ka?
Photographs allow the reasoning is there. ಮೂರನೇ ಪೇಜ್ ತನಕ ಫ್ಯಾಕ್ಟ್ಸ್, 4ನೇ ಪೇಜ್ ಅಲ್ಲಿ ಇಶ್ಯೂಸ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತಾರೆ, 5ನೇ ಪೇಜ್ ಅಲ್ಲಿ ಪಾಯಿಂಟ್ಸ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೆ. ಅದನ್ನ ಬಿಫೋರ್ ಕನ್ಸಿಡರಿಂಗ್ ಮೆರಿಟ್ಸ್ ಪ್ಯಾರಾ 12 ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ. ಪಾಯಿಂಟ್ ನಂಬರ್ 2 paragraph 13 and 14 only 1 page judgment. This is the manner in which first appellate court discharges its duty. There are several judgments of the Honorable Supreme Court right from 2011 to 2018.
You were aware that you had no title, yet your mother executes a registered gift deed only for the purpose of this case.
My submission.
A gift deed hakid takshane immediately after the gift deed the suit is filed. It is obvious that you wanted to create title for the first time in your favor. You were aware of the fact that your mother had no registered child deed.
No, P7, P5 to P8 ಮೂರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಜರು ಮಾಡಿ.
I'll
There are no
consider.
documents.
Anything else?
My only respectful submission is some notice could have been ordered and trusted. Is there at least the
When-
reasoning of the first appellate court when judgment itself looks very, very bad. Now appeal haki
This is a
ನಾವು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀವಿ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಇಲ್ಲ ಅಂತ ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ನವರು ಅದಕ್ಕಿಂತ ಇದಾಗಿ ವಿತೌಟ್ ಇವನ್ ಲುಕಿಂಗ್ ಇನ್ ಟು ದ ಫ್ಯಾಕ್ಟ್ಸ್ ದೇ ಡಿಸ್ಮಿಸ್ ದ ಅಪೀಲ್.
no, I am swayed, like I told you, I'm swayed by the admission of your own client that they have obtained electricity connection, they have produced electricity bills, that according to me.
No. ಆ ಆಸ್ಪೆಕ್ಟ್ ನಾನು ಯು ಹ್ಯಾವ್ ಟು ಕನ್ಸಿಡರ್ ಇನ್ ದ ಲೈಟ್ ಆಫ್ ಅದರ್ ಅಡ್ಮಿಟೆಡ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್.
ಇಲ್ಲ, ನಿಮ್ಮ ಹತ್ರ ಏನ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಇಲ್ಲ.
ಅವ್ರು ಏನ್ ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ದೇ ಆರ್ ನಾಟ್ ಕ್ಲೈಮಿಂಗ್ ಟೈಟ್ಲ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಸೈಟ್ ನಂಬರ್ 7. ದೇ ಆರ್ ಕ್ಲೈಮಿಂಗ್ ಟೈಟ್ಲ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಬೇರಿಂಗ್ ನಂಬರ್ 555 and they have produced documents pertaining to site number 9. ಈ ಸಿಚುವೇಶನ್ ನಲ್ಲಿ ಒಂದು ಸ್ಟ್ರೇ ಅಡ್ಮಿಷನ್ ಆಫ್ ದಿ PWD
ಅಲ್ಲ
ಅವ್ರು ಹೇಳಿದ್ದು ಅದು I leave it.
This is a second appeal by the plaintiff who has failed to establish that Sheena,
the appellant is he.
in possession of the suit property. The case put forth by the appellant plaintiff was that he had become the owner of the suit property, which was a house property, under a registered gift deed dated 25/2/2010, executed by his mother. He stated that the suit property was carved out of number 149/2B, and his mother had purchased the same from her vendor through an unregistered sale deed dated 15/4/1991. And ever since the purchase, she was in possession. She gifted the property in his name. It was stated that the khata had been registered in her name by the jurisdictional Gram Panchayat, and she was also paying Kandayam. It was stated that after the gift, he had also got the khata change in his name and was paying Kandayam and was in possession. So it was alleged that this possession of the plaintiff was sought to be disturbed by the defendants, who were the wife and son of one Madegoda. It was stated that Madegoda had sold the site in the revenue layouts had sold revenue sites formed in number 149/2B, which totally measured 19 guntas in the area 82. And one of the sites sold was in favor of the plaintiff's mother's vendor. It was stated this vendor, namely M. Ramu, under an unregistered sale deed dated 12/2/82. It was stated that the said Ramu had sold the very same property in favor of his mother under another unregistered sale deed dated 15/4/1991. And along with the sale deed, he had also executed a GPA in favor of his mother, apart from an indemnity bond on 15/4/1994. It was stated that the suit property was situated in the revenue layout, and the defendants, who had no right, were trying to interfere with their possession, and therefore was constrained to file the suit. This suit was resisted by the defendants, that is, the wife and son of Madegoda, contending that Madegoda was the owner of 149/2B, measuring 19 guntas, and he had expired on 19/7/1990. And after his death, they had succeeded to the property and were in possession of the same. It was stated that the land bearing serial number 149/2B was their ancestral property, and all the revenue records stood in the name of their father, Madegoda. Madegoda tane?
Madegoda. ಅವರು ಮಾಧು ಅಂತ ಹೇಳ್ತಾರೆ. What he says is,
Yes, Madhu Anta.
but at the same time, subsequently, he admits that his father's name is Madegowda. He goes to the extent of disputing the very name of the person.
It was stated that the defendants had formed revenue sites and in the land and had constructed a small house with AC shed and were residing therein along with their family members. It was stated that they had also taken electricity connection in respect of the house that they had constructed. And the plaintiff had deliberately furnished wrong property number, wrong boundaries and measurement of the suit property. It was stated that the suit property bearing number 555 was situated at 4th Cross Madhevpura and had distinct boundaries in which they had constructed a 5-square AC sheet house on the southern side. They also stated that they sunk a borewell and were drawing water from the said borewell. It was stated that since they were in possession, the suit for injunction could not be entertained. The trial court, on consideration of the evidence adduced by the parties, came to the conclusion that the plaintiff was not able to establish that he was in possession. The trial court noticed that PW2, that is Kalama. Kalama ಅಂದ್ರೆ mother ತಾನೆ?
Yes, mother. Kalama is mother.
The mother of the plaintiff, who had gifted the property to the plaintiff, had herself admitted that the defendants had taken electricity connection to the said house, and therefore it was clear that the possession of the suit property was with the defendants. The trial court accordingly dismissed the suit. In appeal, the appellate court found no reason to disagree with the finding of the trial court. Before the appellate court, an application was also filed for production of additional evidence, which were 2 photographs and the unregistered sale deed executed in favor of Ramu, the plaintiff's mother's vendor. The appellate court refused to entertain the said application on the ground that admittedly the documents were in the file and were not exhibited before the lower court, and the sale deed being unregistered could not obviously be marked. The appellate court accordingly confirmed the finding of the trial court and dismissed the appeal. It is as against his concurring judgments, the present second appeal has been preferred. Learned counsel for the appellant contended that the preponderance of probabilities indicated that the plaintiff was in possession, and therefore both the courts had committed an error in dismissing the suit. He also submitted that the evidence had been misread by both the courts, and a stray admission to a suggestion was construed as an admission, which was impermissible in law. It is not in dispute that the plaintiff claimed to be in possession on the basis of a registered gift deed executed in his favor by his mother. It is also not in dispute that his mother claimed title over the suit property through an unregistered sale deed executed by one Ramu. It is further not in dispute that the said Ramu had claimed title through another unregistered sale deed from Madegowda, the husband and father of the defendants. It is therefore clear that even as per the admitted case of the plaintiff, title was never conveyed to either his mother or his mother's vendor. Thus, prima facie, both the courts were justified in coming to the conclusion that the plaintiff had no title to claim to be in possession. Next paragraph. As far as actual physical possession is concerned, the trial court has noticed that there was a clear admission by the defendant's mother that there was an existing house in the suit property, and to the said house, the defendants themselves had obtained electricity connection. That apart, the defendants also produced the work order and sanction letter issued by the electricity company, and also produced electricity bills to indicate that they were residing in the suit property. A borewell receipt was also produced to show that they had sunk a borewell. So in fact, the sinking of the borewell is also
Sanjay Gowda from NS Sanjay Gowda.
the court were absolutely justified in coming to the conclusion that the plaintiff had failed to prove his possession. There is no substantial question of law arising for consideration in this second appeal. So consequently, the appeal is dismissed. Since the appeal is being dismissed on merits, the application filed for condition of delay is also dismissed. Next Monday. ಯಾರು ಅವರು? In what way is it related? Is he the executant of the agreement of sale?
He made an application for increasing part.
Impleading as what was his right?
He says that Baburji alone has no right to sell the property. He says that he's also having right.
Let him establish that can't be decided in this.
Yes, I got to notice it. Here in the statement, in this case, what happens in the statement? There is no denial of the signature. And witnesses have been examined. I got notice that the plaintiff has examined it and everything else. This was not say the loss of proof has shifted because the plea is not that even in this case, plea is not that it is not a signature. Nowhere it says it is not a signature.
Let us see his written statement.
But the written statement I have.
The plaintiff has created and concocted the agreement of sale, and defendant number 1 has not executed any agreement of sale in favor of the plaintiff in respect of suit property. Yes, he has said that. The plaintiff has created and concocted the agreement of sale, and defendant number 1 has not executed any agreement. What is the meaning of created and concocted? No, that is not his case. If he had said that, I had signed blank papers to him and he has misused it.
He doesn't take a stand at all.
Yes, stated the entire agreement of sale was created and concocted. He has not executed any agreement of sale. Is a specific government.
So here, this is here also.
Forget about his case. For you to apply this decision.
Similar,
Here, this was a case where the signature was not denied in the written statement. Here is a case where the denial was in the examination in chief during the course of evidence.
In the written statement, there is a denial of every fact in the claim.
That is different from saying.
Here also there is a denial of every fact in the claim. But here,
He categorically says he has not executed any agreement of sale in your favor. This was a case of a money suit in which the entries in the books of account.
the increase in the books of accounts do not.
Yes.
The present case is not one such case where the entries have chosen not to reduce the gain. They have examined witnesses, pro and increase in the books of accounts, and also pro the economic duties and benefits. The defendant on contrary, except making a bold denial of the elements, had not stated anything else. That apart, nothing was put to the witness in the cross-examination. He only came with a spacious plea in his evidence, which was not pleaded. Thus, he had no hesitation in putting that the High Court has fallen into error.
The facts of that case, correct. The facts of that case, because of that particular fact.
They are not considered all the 6 cases. The said aspect can be looked from another angle. 2, 3, 4, and 5 of order 8 form an integral for dealing with the manner in which delegations of fact and state should be traversed and legal consequences flowing from its non-compliance. It is obligatory on the part of the defendant, specifically with each allegation, and when the defendant denies any such practice, he must not do so easily, but answer the point of substance is clearly postulated. That it shall not be sufficient for the defendant to deny generally the grounds alleged by the defendant, but we must be specific to each allegation of fact. So what happens? I say he has executed an agreement. He says no, I have not executed. That is not the he simply says that in fact
No, let me understand. In what way should you have said about the denial?
he must say that it is in fact in this statement they say they are not say that
Forget about this judgment. I want to learn from you.
he is not signature on any document.
What is the meaning of this word in his written statement? That he has not executed any document.
He does not say so.
He says that. Paragraph, page number 44. And defendant number 1 has not executed any agreement in favor of the plaintiff in respect to suit property. That is a specific case. Now I am going by the judgment, paragraph 4, page 44.
The plaintiff created and concocted the agreement of sale, which is in this case. Friend number 1 has not entered any kind of agreement with the plaintiff. It is a stranger to the and he himself says he has taken rupees to make a base transaction. That is the only we got as far as agreement.
Clearly, the paragraph B created and concocted the agreement of sale which he filed in this case. Defendant number 1 has not entered into any kind of agreement of sale with the plaintiff to sell the social property. The plaintiff is a stranger to the defendants. There was no denial in the written statement regarding the signature at all. Here it is a specific case of a denial.
Paragraph 22. Obligated on the part of the specifically deal with each allegation.
That is a specific denial. You say the agreement of sale. He says, no, you have created the agreement of sale.
He has the copy of the agreement that I have. He does not deny the signatures. And in fact, in cross-examination, he admits to all the signatures. So therefore, my submission is the burden of proof shifts. The onus of proof. Burden will not shift. The burden will continue to be on the plaintiff itself. Onus of proof. When I examine two witnesses for proof who are attesting witnesses to the unit, maybe the Lord have constructed, maybe these witnesses are my witnesses. But requirement of law is not that I must examine those witnesses. I have examined those witnesses, have identified these signatures. He admits two of his signatures. And then he is inconsistent and he denies his signature on the affidavit itself. His examination in chief. However, in such circumstances, the onus shifts on him to examine his file. Onus to examine an expert shifts on him to show that it is not his. Rightly or wrongly, not he has admitted. But in fact, in section 73, the courts have, but there is no fighting on that. Both the courts are silent whether they have exercised their right.
Yes.
Both the courts are not given writing. That is my suggestion that at that stage is for the defendant to examine an expert to show that he is not, because he is inconsistent. He himself relies his signatures on couple of pages on the agreement and he agrees on the problem. Now the other thing is that that he has signed in Telugu.
Still, where is that deposition that you gave last year? Officer Sondra? You give me the agreement of sale as well as yes.
They also have not hit. Like the burden of proof is on me that I have examined. Courts have not exercised use. Since everything the courts have said, does not in the light of the fact that he admits two of the signatures of the agreement. They may not be correct, like the last says, maybe legal because once he says that, the burden shifts on. The burden shifts on the defendants. So, in what circumstances those signatures are, or they are not his signatures. And if that is true, that can be complete. That is what you have got. Or if the courts were to have exercised the impacts which is on that, which is the significance of the agreement, then you not there are that. Here in both the trial court as well as the appellate court, they don't exercise. There is no, in fact, the courts do not consider it. It is of the courts. There are some issues. The bonus have shifted about. It doubts whether it is or for the courts to have like in this taken for the court, the bond of proof is once a person who has seen the discussion side is examined and he signs testimony and his testimony is not regular, then there are courts which
This is the second appeal by the plaintiff was failed in both the courts to establish that he was entitled for a degree of special performance. Next. It was a case of the plaintiff that an agreement of sale had been executed in his favor, whereby the first defendant had agreed to sell the suit property for a total sale consideration of rupees 50,000, and he had in fact paid the entire sale consideration of rupees 50,000 on the very same day. It was stated that the possession of the property was also delivered to the plaintiff, and he had in fact constructed a house and had erected a compound wall by putting stone slabs and was in possession. It was stated that the first defendant had undertaken to execute the registered sale deed after the Fragmentation Act was repealed, and though the plaintiff had requested and demanded the first defendant on several occasions to execute the sale deed, the first defendant did not come forward. It was stated that the plaintiff had learned that the kata of the suit property had been transferred in the name of the first defendant's wife, that is the second defendant, and hence he had caused the issuance of a legal notice dated 12/12/2012, calling upon the defendants to execute the sale deed. He stated that the defendants, on the other hand, in reply, he stated that the defendants had given a vague reply and had failed to execute the sale deed, and he was therefore constrained to approach the court. Next, the defendants entered appearance and resisted the suit. The defendants contended that the suit property was their ancestral property, and the first defendant had executed a registered gift deed on 8/5/2012 in favor of his wife, and the records were accordingly mutated in their name. They stated that they were in actual possession and enjoyment of the suit property, and that the plaintiff had created and concocted the agreement of sale. It was stated that defendant number 1 had not executed any agreement of sale in favor of the plaintiff agreeing to sell the suit property, and the plaintiff was a stranger to them. It was also contended that the suit property was not valued, and the stamp duty on the market value of the property was not affixed. It was alleged that the market value of the suit property was rupees 2 lakhs, and if that be so, the plaintiff ought to have paid the full stamp duty. A plea was also raised that the suit was barred by limitation. In the pendency of the suit, the third defendant got himself impleaded contending that he had right in the property. The first defendant had no right to execute any sale agreement in favor of the plaintiff. The trial court, on consideration of the evidence adduced, recorded a finding that the first defendant had failed to execute an agreement of sale on 29/8/2008 in respect of the suit property for a total sale consideration of rupees 50,000 and had paid this entire consideration of rupees 50,000 to the defendant. The trial court also held that the plaintiff had not established that he was ready and willing to perform his part of the contract. It was also held that the defendants had proved that the suit property was not properly valued and the court fee paid was insufficient. The trial court accordingly dismissed the suit. Being aggrieved, the plaintiff preferred an appeal. The appellate court, on reappreciation of the evidence, concurred with the findings recorded by the trial court. The appellate court came to the conclusion that the judgment passed by the trial court was neither capricious, arbitrary, nor erroneous. It accordingly proceeded to confirm the finding of the trial court and it dismissed the appeal preferred by the plaintiff. As against these concurring judgments, the present second appeal has been preferred. Senate counsel for the appellant contended that notwithstanding the denial of the execution of the agreement of sale, the plaintiff, during his cross-examination, had admitted the signature found on the agreement of sale to be his signature. He submitted that the first defendant had also admitted that he had received the sum of rupees 50,000. And these two factors conclusively prove the agreement of sale had been duly executed. Senate counsel also submitted that the defendant, first defendant, had the burden of proof, though was initially on the plaintiff, to establish that the first defendant had executed the agreement of sale. On examination of the witnesses to the agreement of sale, the onus had shifted on the first defendant. So he submitted that the first defendant did not get the document referred for a forensic examination. And therefore, it was clear that the signature of the defendant on the agreement of sale had stood established. He also submitted that both the courts have not exercised their power under Section 73 of the Evidence Act and compared the signature to come to the conclusion that the agreement of sale was not executed and therefore the judgments are unsustainable. I heard the learned counsel for the appellant and also produce the material on record. It is the specific case of the plaintiff that he had entered into an agreement of sale on 29/8/2008, agreeing to purchase the property bearing survey number 4/1B, measuring 3 guntas for a total sale consideration of rupees 50,000. It is a specific case that he had paid the entire sale consideration of rupees 50,000 and was also put in possession of the said property. The agreement of sale, which was relied upon by the plaintiff, has been found to be materially altered by the trial court. That apart, the agreement of sale contains the following recital. ಇದೇ ತಾನೆ ಸದರಿ ಜಮೀನನ್ನು ಸರ್ಕಾರಿ ಕಾನೂನು ಪ್ರಕಾರ ನೋಂದಾವಣೆ ಆಗದೇ ಇರುವುದರಿಂದ ಇದೆ ಅಲ್ವಾ? This is the funding portion. It is therefore clear that according to the plaintiff, the reason for non-execution of a sale deed, despite paying the entire sale consideration, was because of a bar for registration of the sale deed in respect of fragments of land. It cannot be in dispute that as on 2001 alva, cannot be in dispute that way back in the year 1991 itself, the Karnataka then consolidation was repealed. It is therefore clear that the reasons set forth in the agreement of sale for non-registration of the sale deed cannot be accepted. It is to be noticed here that if the entire sale consideration rupees 50,000 was paid and possession was delivered, the question of the sale deed not being executed immediately would have to be explained by the plaintiff. Though in the agreement of sale, there was a recital that there was a ban on registration. In the legal notice issued by the plaintiff, there is absolutely no averment regarding the ban being lifted or an assertion that the sale deed could not have been registered due to the ban. In fact, the averment in the legal notice is to the effect that the plaintiff had requested and demanded the defendant on several occasions to execute the registered sale deed, and yet the sale deed was not registered. So, an altogether new ground is sought to be raised that certain documents were to be ascertained regarding the suit property in the legal notice. This conduct of the plaintiff creates suspicion as to whether an agreement of sale was in fact executed and the entire sale consideration was paid. So this suspicion becomes further amplified by the fact that waited for 5 years to approach the court suing for specific performance. So both the trial court as well as the appellate court have noticed these contentions and have concluded that this was not a fit case for granting a degree of specific performance. Since both the courts have recorded a clear finding of fact that the execution of the agreement of sale was not established, the scope for interference in the second appeal under section 100 being limited, the question of execution cannot be examined afresh. Next paragraph. Learned counsel for the appellant, however, contended that there is an admission regarding the signature on the agreement of sale. And therefore, this admission would render both the judgments unsustainable. ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇರೋದು ಅದು? Cross examination. ಇದೆ ಅಲ್ವಾ? Seven one. The deposition of the defendant in the cross examination reads as under. This will be given to you afterwards. A perusal of the deposition would indicate that the defendant was essentially denying virtually every signature of his, including the one that was found on the wakalat. In my view, the reliance upon this admission to come to the conclusion that the execution of the agreement of sale was proved and stood established would not be safe and proper. The trial court as well as the appellate court have recorded a finding that the execution of the sale agreement had not been established by taking into consideration the attendant circumstances. I find no reason to disagree with the finding of the appellate of both the courts. As far as the assertion of the learned counsel that the agreement of sale was not specifically denied and the onus was on the defendant to seek for reference, expert is concerned, in my view, this assertion is ill-founded. The entire burden of proof regarding execution of the agreement of sale was upon the plaintiff alone. In the light of the specific and categorical plea that the agreement of sale was created and concocted and that the defendant had not executed the agreement of sale, the mere production of witnesses to establish the execution of the agreement of sale cannot be a conclusive fact. In the light of the specific denial regarding execution, it was incumbent on the plaintiff to have sought for reference. And this burden of proof cannot be shifted to the defendant merely because the witnesses had been examined on behalf of the plaintiff. It is to be kept in mind that the execution of an agreement of sale would be the primary consideration for the plaintiff to claim a degree of specific performance. If this foundational fact is not proved, the entire claim of the plaintiff will come to a naught. In the present case, the plaintiff claims that an agreement of sale was executed under which the entire sale consideration was paid. The consideration of rupees 50,000 is sought to be paid in one lump sum. There is no evidence on record as to how many deliberations took place before this sum of rupees 50,000 was agreed upon. The courts below have found that the name of the plaintiff's son has been entered in the agreement of sale after a whitener had been used to delete the name earlier printed. These are circumstances which create a serious doubt regarding the execution of the agreement of sale. The plaintiff in such an eventual in such a situation was required to establish that the first defendant had executed the agreement of sale beyond all reasonable doubt. The fact that the plaintiff waited for 5 years before making a demand for conveyance of the property by way of a registered instrument also establishes that the plaintiff also creates a doubt on the entire transaction. The liens placed upon by the learned counsel regarding the burden of proof, that is, in the case of Gyanchan, year 2013 Supreme Court 1078, can be of no avail, since in that case there was no specific denial of the signature and was only a bald denial of the averments in the written statement. In the instant case, there is a specific plea regarding the very execution of the agreement of sale by the defendant, and therefore the burden of proof was entirely on the plaintiff, and the onus would not shift on the defendant. For the reasons stated above, I find no substantive question for resolution.
Eleven, my lord.
Yes,
Yes, I'm for the respondent.
ಆಮೇಲೆ ಕೊಡ್ತೇನೆ ನಾನು. Yes. KL Srinivas.
Respondent.
ಬಂದಿದ್ರ ಸೂರ್ಯಕುಮಾರ್. We'll give him one more chance. Next
Please.
week, if it does not,
Please.
the appellant is unavailable. Is this matter next Monday?
Bless.
Suit for ejectment. Hotel business.
The group was five. The one
Relationship is not in dispute. Relationship is not in dispute.
There is God and the society are wife and children of one. He Ramling.
He Ramlinga.
He Ramling. And in fact, the women was tenant from 2002. And he was tenant
Tammegoda.
from 2002. And the relative, other relative, he Ramling died in school. And he died there. There was that not die.
So you admit that you are paying the rent to the plaintiff on behalf of the family of the deceased Tammegoda. You admit that in your written statement.
Yes, that is true. But so far as the properties of Tamil, there was serious dispute.
Even according to you, Tammegoda brought the plaintiff to your hotel and you accepted that. You accepted that.
No, I have not accepted that the Ramligaya is the owner of the property.
No. You accepted that according to page number 60, this is your government. During the lifetime of the said Tammegoda, plaintiff has come to the hotel of the defendant and the said Tammegoda introduced the plaintiff to defendant as his son. And the landlord Tammegoda was not in a position to come to the ship premises, the plaintiff used to collect the rent.
I don't know, that's my stand on the case. But the case of the plaintiff, that the defendant is a tenant from 2005, and an agreement was between the Ramligaya and the Ramligaya, the original plaintiff, and the and such an agreement was produced, but it's not passed because of that it is stated in 3 years. But my case is, I am a tenant under Tamil. And there was a suit, 2004 there was a suit filed, Tamil has 2 owners. And suit was filed, 258 was to go, partition 2.
2004.
2004. Because several properties of several properties of Tamil, including this scheduled property. And the plaintiffs here claim that this scheduled property, Tamil has bequeathed, executed a will in favor of P. Raman. And in this short draft, defendant was party and he had deposited the rest. Despite of it, the trial court has concluded without any basis that the defendant is involved in the process. The evidence also has come.
No, if you are saying that he is not the landlord, the question of you paying rent also will not arise. Alva.
But what is the default of rent? I have deposited 20 years. It plays for 2 days for this market. The documents I can place to you. But my submission is because the ownership of the property is concerned. Serious dispute and
Now, is it open for the tenant to raise this dispute in view of this government that he came and introduced you to his son and you continue to pay the rents to the son? That is sufficient to establish relationship. How does it lie in your mouth? Are you not stopped from saying that plaintiff is not the owner after you yourself admit? But as a tenant, when Tammegoda came and introduced the plaintiff to be his son, and you accepted that and continue to pay rents to him, can you now say that Ramlinga is not entitled to sue for your rejectment. ಅದು ಬೇರೆ, ಅದು ದಾವ ಅವರಿಬ್ರು ಗಂಡ ಹೆಂಡತಿ ಇಬ್ರು ಹೆಂಡತಿ ಜಗಳ ಆಡ್ತಿದ್ರು, ಅಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡೋದು. ಬಟ್ ನೀವು ನಿಮ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಆಸ್ ಎ ಟೆನೆಂಟ್ having accepted.
My case is on behalf of Tamil Nadu, you to come supply. And the rents are paid.
Why would you pay? Why would you pay?
Rents are paid. As Tamil Nadu requested to pay the rent. And I continue to be a tenant. Tamil Nadu. Now, 2004.
ನೀವು ಹೆಂಗಿರೋ ಆ ಹೋಟ್ಲು ನಡೆಸ್ತಾ ಇಲ್ಲ, ಸುಮ್ಮನೆ ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ. ಯಾಕೆ ಸುಮ್ಮನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾಕೆ?
November 2019, that's my idea. November 2019, this portion of this hotel property is sold to third party.
ನೀವು ಯಾಕೆ ತಲೆ ಕೆಡ್ಸ್ಕೊಳ್ತೀರಿ? ನೀವು ಸುಮ್ಮನೆ ನೀವು ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ, ಅವರು ಕೊಂಡ್ಕೊಳ್ಳೋರೇನೋ ಅವ್ರು ಮಾಡ್ಕೊಳ್ತಾರ. Why are you concerned with all that? You are a tenant. Your right can't be enlarged to that of a owner or as any other right. Your right to continue there is only as a tenant. You admittedly not paid the rents.
So far as the rent is concerned, my lord, I have paid my.
No, that can't condone the payment of rent merely because you have some difficulty. That does not waive your obligation to pay the rent. If you not paid the rent, you suffer the consequence.
The respondents are not the owners.
Is it open for you to contend that?
They are not the owners. By virtue of this registered sale agent, I have already transferred. Now the execution is filed by the tenants.
ಏನಿಲ್ವಾ? 258 ಇರ್ಲಿ ಬಿಡಿ. How did the trial court deal with this contention of yours that they were not the owners?
And in fact, the rents are paid on the two only. And one more point for your consideration is issue number 1 is issue number 1.
Don't worry, I will make it clear that this will be subject to the ultimate decree passed by 2004. ಯಾರ್ ಓನರ್, ಯಾರ್ ಭಾಗಕ್ಕೆ ಬರ್ಬೇಕು ಅಂತ ಆದಾವಲ್ಲಿ ಇತ್ಯರ್ಥ ಮಾಡ್ತಾರೆ. ನೀವು ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ ಅಷ್ಟೇ. ಏನೋ ಮಾಡ್ಕೊಳ್ತಾರ ಅವ್ರವ್ರ ಪಾಪ.
Page 63. Interval page 11. What is the whether the place proves that he is the owner of the good business property. And the trial court answers with saying that it is not necessary. Not necessary. The internal page 11 of the trial court. Page 63. 63 issues.
ಸಿಕ್ತು.
Issue number 1. The trial court answer does not arise as this suit is not item. Fact remains
ನಾನು ಹೇಳಿದಾರ ನೀವೇ ಒಪ್ಕೊಂಡ್ರಿ ಅವ್ರ ಮಗ ಅಂತ. ಏನ್ ಬಿಡಿ, ಆಯ್ತು. I will ask that rent to be set off. The rent that you deposited, they will not be entitled to claim in the execution. ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನ್ ಮಾಡಿದಾರೆ?
trial court ಅಲ್ಲಿ judgment ಆಗಿದೆ.
ಡ್ಯಾಮೇಜಸ್ ಎಷ್ಟು ಮಾಡಿದಾರೆ? ಡ್ಯಾಮೇಜಸ್
The damages from 2008 is in spite of the fact that I have reported rents in 258.
that is apart from the rent. This is damages. ಆತರ ಏನಿಲ್ಲ.
In
ಎಷ್ಟಿದೆ ಬಾಕಿ ಎಷ್ಟಿದೆ ನಿಮ್ ಪ್ರಕಾರ?
Judgment passed again.
Array was passed
In September.
January 19. ಎಷ್ಟು ಬಾಡಿಗೆ ಎಷ್ಟು?
So, that you want to find 100 kg, operating for the other. The liquid is also narrated to say that means that the rate of now on this the calculation is made. Only 1,82,000 was there. 1,82,000 and on 2020 the execution is 5. 1,82,000 is claimed.
ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟಿದೆ ಬಾಕಿ? ಎಷ್ಟು? ನೀವು ಲಾಸ್ಟ್ ಎಷ್ಟು ಕಟ್ಟಿದ್ರಿ, ಇವಾಗ ಎಷ್ಟು ಬಾಕಿ ಇದೆ?
Sometimes it is paid to the other council in the board. Sometimes it is required.
ಬಿಡಿ, ಅವ್ರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡಿದಾರೆ, ಅಲ್ಲಿ ವಸೂಲಿ ಮಾಡ್ಕೊಳ್ತಾರೆ. ಐ ಕ್ಲೋಸ್ ದಿಸ್ ಮ್ಯಾಟರ್. I thought if you wanted time, I can give you time, provided you deposit the entire arrears and give you time. When you don't want time, we'll dismiss second appeal. They will take possession of accordance.
I will make a submission.
ಇಲ್ಲ, ನೀವು ಎಂತ ಟೆನೆಂಟ್ ಲೆಕ್ಕ ಹಾಕೊಳ್ಳಿ, ಎಷ್ಟು ಬಾಡಿಗೆ ಕೊಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಿಲ್ದಿದ್ರೆ ನಿಮ್ಗೆ 2 ವರ್ಷದಿಂದ ಇಲ್ಲ ಹೆಂಗೆ? how can those people, you are taking advantage of the fact that they are litigating from 2019. You know that there's a dispute. You knew that you were supposed to deposit in OS 258/94, and yet for the past 2 years you will not deposit a single pi. Why should we show leniency to you? Not for 2 years, Mr. Regde, not for 2 years. This is 2019. 2020 ಅಲ್ಲಿ ಏನು 2020 ಅಲ್ಲಿ ಕೋವಿಡ್ ಬಂದಿದ್ದು, 19 ಇಂದ 20 ವರೆಗೂ ಏನು ತೊಂದರೆ ಇರಲಿಲ್ಲ, 1 ವರ್ಷ. 19 ಇಂದ January 19 is the order. January 19 is the order. ಮತ್ತೆ March 20 ಅಲ್ಲಿ ಬಂದಿದ್ದು ಲಾಕ್ ಡೌನ್ ಎಲ್ಲ. For 1.5 years, if you not paid the rent, it's clear that you're taking advantage. Why should we lenient to you? Guarantee time. I'll grant you a week. All right, next Monday. Call this on next Monday. ಅವ್ರು ಹೇಳ್ತಾರೆ ಎಷ್ಟಿದೆ ಅಂತ, ನೀವು ಅಷ್ಟು ಕಾಸು ಕೊಡಿ. ಇವಾಗ ಅವ್ರ ಪ್ರಕಾರ ಎಷ್ಟಿದೆಯೋ ಅಮೌಂಟ್ ನೀವು ಅಷ್ಟು ಡಿಪಾಸಿಟ್ ಮಾಡ್ಬಿಡಿ. ನಾನು ಐ ವಿಲ್ ಆಸ್ಕ್ ದಿ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್. 1,82,000 ಕೇಳಿದಾರೆ ಅವ್ರು, ಅಲ್ವರಾ?
In spite of the fact that I had deposited
How much did you deposit? ಹೇಳಿ, ಫಿಗರ್ ಹೇಳಿ ಸಾಕು, ನಮ್ಗೇನು ಮ್ಯಾಥಮೆಟಿಕಲ್ ಪ್ರಿಸಿಷನ್ ಅವ್ರು ಆಮೇಲೆ ಮಾಡ್ಕೊಳ್ತಾರೆ.
but the calculation is usually verified from the calculation. December 2008 is the calculation. And that has come 1,82,000 in September 2020. At the execution. So I will calculate and
ನೀವು ಡಿಪಾಸಿಟ್ ಮಾಡಿ ಬೈ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ, Wednesday, next Wednesday. And counsel for the respondent appellant submits that you would verify and inform the court as to what was the amount deposited in OS 258/2004 and what is the actual amount that was required to be paid as rents. Next Tuesday, next Wednesday. Wednesday. Next Wednesday. ಇಲ್ಲ ನಿಮ್ಗೆ ಅವಸರ ಇರಬೇಕು, ನಿಮ್ಗೆ ನಾಳೆನೆ ಬೇಕಾದ್ರೆ ಹಾಕೊಡ್ತೀನಿ, ಬರೀ ಅಮೌಂಟ್ ಎಷ್ಟಿದೆ ಅಂತ ಹೇಳ್ಬೇಕು. ಇಲ್ಲ ಫಸ್ಟ್ ನೀವು ವೆಕೇಟ್ ಮಾಡಕ್ ಟೈಮ್ ಕೊಡೋದು ಓನ್ಲಿ ಇಫ್ ಯು ಡಿಪಾಸಿಟ್ ದಿ ಎಂಟೈರ್ ಅಮೌಂಟ್ at one go. You will not be granted time to make a deposit because for 2 years you have enjoyed without paying a single pay as rent. First deposit, then you leave it to me, I will grant you reasonable time.
Appear for the appellant, my lord.
I beg to appear for the respondent 1 to 3 to 6. Respondent and 3 to 6.
My lord, the plaintiffs and defendants, they are closely related. Land tribunal grant occupancy.
ನೀವ್ ಯಾರ್ಗೆ? plaintiff ಗ defendant ಗ?
I am defendant number 4.
2 and 3 ಅಂತ ಇದೆ.
ಅಲ್ಲ ಅದೇನೆ ವಾಸಂತಿ and Madhavi and Lakshmi.
Suit was filed by Nagamma.
ಹೌದು, Nagamma and brothers and sisters of these two defendants.
Family tree ಏನಾರ ಇದೆಯಾ? Relationship?
Family tree ಕೊಟ್ಟಿದ್ದಾರೆ, but dispute is not regarding family tree or relationship.
ಇಲ್ಲ ನಾನು ಯಾರ್ಯಾರು ಅಂತ ಗೊತ್ತಾಗಕ್ಕೆ.
Balu Moili has got one son and one daughter. ಅದು plaintiff ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ನನಗೆ ಅವರು ಕಳಿಸಲಿಲ್ಲ. ನಾನು ಮೊನ್ನೆ ಕೂಡ ಹೇಳಿ ಕಳಿಸಿದ್ದೆ ಅವ್ರ ಕಡೆ.
ಏನೇನು?
ಫ್ಯಾಮಿಲಿ ಟ್ರೀನ ಲ್ಯಾಂಡ್ ಟ್ರೈನ್ ಆರ್ಡರ್ನ ಸ್ವಲ್ಪ ಕಳಿಸಿ ಅಂತ ಹೇಳಿದ್ದೆ. ಅದು ನಂಗೆ ಇನ್ನೂ
Our the plaintiffs and defendants related.
One Balu Moili has got one daughter and one son. Daughter name is Bamu Moili.
Balu Moili na?
Balu Moili has got one son and one daughter. Bamu is a daughter and Rama is sister, brother.
No, sister ಏನು?
Bamu, BAAMU. Bamu, BAAMU.
Daughter.
ಹೌದು, ಬಾಲು ಮೊಯ್ಲಿ ಮಗಳು ಬಾಮು ಮೊಯ್ಲಿ and son Rama Moili. Rama Moili's wife is Nagamma, first plaintiff.
Wife is Nagamma.
Nagamma, she is first plaintiff.
Who is the second plaintiff? Balkrishna.
Second and other defendants are sons and children of Bamu Moili.
Daughters, children.
Daughters and sons of Bamu Moili.
La. P2 is Balkrishna Shriyan.
All are sons of Bamu Moili's sons and daughters.
And Umesh is also the son of Bamu.
ಹೌದು, ಅವರೆಲ್ಲ ಅವ್ರ ಮಕ್ಕಳೇನೆ, ಅದು ಸಂಬಂಧ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ.
ಪದ್ಮನಾಭನು ಅವರೇನಾ? ಪದ್ಮನಾಭ ಇರೋ ಸನ್ ಆಫ್ ವೆಂಕಟ ಅಂತ ಇದೆ.
ವೆಂಕಟ ಅಂದ್ರೆ ಬಾಮುನ ಗಂಡ. ಆಲ್ ಆರ್ ಬಾಮು ಸನ್ಸ್. ಅದು ಆಲ್ ಆರ್ ವೆಂಕಟ ಅಂತ ಅವರೆಲ್ಲ ಬಾಮು ಮೊಯ್ಲಿ ಮಕ್ಕಳು.
ಹೂ ಇಸ್ ವಾಸಂತಿ?
ವಾಸಂತಿ ಅಗೇನ್ ಇಸ್ ಡಾಟರ್.
ಡಾಟರ್ ಆಫ್
ಬಾಮು ಮೊಯ್ಲಿ.
Then Lakshmi?
All plaintiffs and defendants except first defendant. Alla, first plaintiff.
Now, what about Rama Moili? He was not a party here.
Yaru?
Maga. You said Rama Moili. You said Bala.
Rama avri makkale yaru illa. They died issueless. Rama Moili, Nagamma died issueless.
So the fight is only between the mother and
sisters
the grandchildren.
ಹೌದು, grandchildren ಬಾಲು ಮೊಯ್ಲಿ. ಅದು ಬಾಲು ಮೊಯ್ಲಿ ಅವರು he too has expired, leaving behind Bamu and Rama. Now these plaintiff and defendants are.
Hello, Nimsha. Nagamma is also dead.
Nagamma also dead.
Right. Interstate.
Interstate.
So the entire property now goes only to the grandchildren.
Sons and daughter of Bamu and Venkat.
Bamu is also not alive.
Bamu is also dead.
So only among the grandchildren.
ಹೌದು. Now what
That
happened
is
was,
P2, P3, P4, D1 and D2.
ಹೌದು,
And D3 and Ellaruna,
D4
all of
and
them.
5 are grand daughter of second son, Balakrishna.
Arrow D4 and
D5, last two defendants. Now they have been proscribed as defendants. Earlier they were plaintiff number 2A and 2B.
You're confusing me. Who's Balakrishna? D5 and D6. So P2 is the son, P3 is the son, P4 is the son. D1, D2 and D3 are the daughters. D4,
D4 is also a daughter.
Son.
Chandrasa is the second
Son.
son.
Second son.
second son yaru? Of
Bamu ಅವರ ಮಗ.
ಇಲ್ಲ ಬಾಮು ಅವ್ರ ಮಗ ಬಾಲಕೃಷ್ಣ ಶ್ರೇಯ ಒಬ್ಬ, ಉಮೇಶ್ ಒಬ್ಬ, ಪದ್ಮನಾಭ ಒಬ್ಬ.
ಹೌದು
ಅಲ್ವಾ?
ಹೌದು.
And D4 ಚಂದ್ರಹಾಸ.
ಹೌದು ಹೌದು.
So 3 sons.
ಹೌದು. And 4 daughters.
ಯಾರು ಇನ್ನೊಬ್ರು ಯಾರು?
ಪದ್ಮನಾಭ, ಚಂದ್ರಹಾಸ.
ಅಲ್ಲ, 1, 2 ಬಾಲಕೃಷ್ಣ, ಉಮೇಶ್,
ಚಂದ್ರಹಾಸ, ಪದ್ಮನಾಭ.
4 sons and 3 daughters.
Yes, my lord.
What is the trial court done now?
Trial court has given 1/7 share each.
Appellate
Appellate
court
court modifies the order, denies the share of Bamu to these two defendants, to these two appellants. The facts are like this, my lord. Land is granted, occupancy right was granted in favor of Nagamma, the first plaintiff, and the brother of these defendants, who is no more now, Devadas.
ಇಲ್ಲ 1/14 ಮಾಡ್ಬಿಟ್ರ?
ಅಲ್ಲ 1/14 ಆಗುದಿಲ್ಲ,
1/14
ಬರ್ತದೆ.
Appellate court has granted 1/14.
Please.
On what basis?
Saying that Bamu Moili and Nagamma died intestate, her share. Devadas died intestate, unmarried, his share.
ದೇವದಾಸ್ ಯಾರು?
Devadas is the eldest son of Bamu Moili. He has filed form number 7.
ರಾಮ ಮೊಯ್ಲಿ ಅಂತಂದ್ರೆ
5th son has filed form number 7. He is no more.
Daughters. One of the son was Devadas. He died in the street, not and that's natural.
What he told me was Bala Moily was a propositus. Nagamma is his wife.
Balumoili is the propositus. He had one daughter, Bamumoili.
Balu Moily.
And Ramamoili, son.
ಇನ್ನು ಮಗ ಹೆಸರೇನು?
Ramamoili.
ರಾಮ.
Rama.
ಯಾರು ದೊಡ್ಡವರು?
Ramamoili's wife is Nagamma. That is plaintiff number 1.
The other son?
No, as Ramamoili and Nagamma.
No. Bala Moily had no other sons, only one son. Rama Moily.
One son, one daughter.
Daughter is in
Bamumoili.
Bamu.
B-A-M-U. Bamumoili's husband is Venkat. Bamumoili had 5 sons and 3 daughters.
3 daughters. That is
one of the sons Devadas.
That is P2.
P2, D1, D2.
P2, P3.
P2, P3,
P4 and
D4 are the sons.
Daughters are
D1, D2, D3.
D2 and D3. Nagamma is now therefore the daughter-in-law of the family.
Yes, sir.
She filed the suit.
Illa.
Partition. Nagamma alva?
And plaintiff number 1, she was plaintiff number 1.
Nagamma and the sons of Bamu Moily,
Yes, sir.
apart from D4, filed the suit for partition.
Yes,
So according to this, Nagamma would get half and Bamu Moili would get half. But now that Nagamma is dead, the entire property goes to Bamu Moili. So Bamu Moili, the entire branch gets 1/7, 1/8, because you said there are 8 children.
One of the son, my lord Devdas, predeceased made as a bachelor.
Yaru adu?
Devdas.
He's not a party here.
He's not a partner. He died on 8877.
And he's no more.
Therefore, there are 7 heirs. 1/7 share. Correct. Then why did the appellate court grant 1/14?
The appellate court notes that my lord Nagamma share.
King Nagamma Satodra automatically.
Everybody succeeds, my lord. 7% succeeds.
Then
Nagamma's a half share. And so far as the Bamu Moili's half share is concerned, only male people succeeds. The order of the land tribunal and other aspects.
no, whether it's the order of land tribunal or the property set of the of Balu Moili.
Balu Moili, my lord, form number 7 was filed by Devdas and Nagamma jointly.
Whoever files the form number 7, ultimately it endures to the benefit of the family if the family was a tenant of the entire land.
There was a specific time.
What do you mean by so if it's filed by Nagamma and by Devdas, it indicates it is a tenancy of the family. How can it be Nagamma's exclusive grant?
Number 1, my lord, was filed. Circular of this was filed by, my lord.
ಎಲ್ಲರಿಗೂ ಒಂದು ಸೆಂಟ್ ಬರ್ಬೇಕು ಅಷ್ಟೇ ತಾನೆ. Prasad or client? Chandrasa is which defendant? The
Is
son.
defendant number. I represent.
It is
Defendant
on
number
Chandrasa who filed appeal. RA was filed by Chandrasa, contrary his own pleading. What he says is,
ಹೆಂಗ್ ಸಿಗುತ್ತೆ ನಿಮ್ಗೆ ಮೂಲಿ ಅವರ?
My lord, I challenge the total decree itself, but somehow the interpretation given by the first appellate court is on a different footing altogether.
ಎಲ್ಲರೂ 7ನೇ ಒಂದು ಭಾಗ ತಾನೆ, ಅದ್ಯಾಕೆ why are you people fighting?
Yes, that is what seems, my lord, because Nagamma's share also the first appellate court determined.
If they withdraw the appeal, you will get lesser share now.
How? That was not the argument canvassed before the first appellate court by me, but it was different footing. But first appellate court has given its own finding.
He is right, then you will get only 1/14 share. You will not get even 1/7.
How?
ಯಾವ್ದ್ರಲ್ಲಿ ಬರುತ್ತೆ? ಹೆಂಗ್ ಬರುತ್ತೆ?
ರಾಮಮಂದಿರದಲ್ಲಿ 1/10 ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಹೆಂಗ್ ಬರುತ್ತೆ ಅಂತ? I will get 1/10 exclusively.
Get my lord 1/14 plus 1/10.
1/10 ಹೆಂಗ್ ಬರುತ್ತೆ ನಂಗೆ ಅರ್ಥ ಆಗ್ತದೆ. ಇದನ್ನ
ಇಲ್ಲ ಸರ್, ರಾಮಮಂದಿರದಲ್ಲಿ only male citizens were awarded in the share by the first.
how can that be? That can't be done, right?
For the reasons are assigned by first appellate court for these cases. They are daughters, my lord, they are married.
Vinita Sharma ಎಲ್ಲರಿಗೂ ಬರುತ್ತೆ. What difference is it?
Then my lord, the other reason was that exhibit P12 and P13 order of the land tribunal and the form number 10 issue only in the name of other children, my lord. Not name of these appellants were not in the.
Other children ಅಂದ್ರೆ ಯಾರು?
Except Lakshmi and Madhavi, who are the appellants before my lord.
ಇಲ್ಲ ಫಾರ್ಮ್ ನಂಬರ್ 10 ಯಾರಿಗೆ ಹೆಸರು ಕೊಟ್ಟರು?
Excluding Lakshmi and Madhavi, others had names are there, my lord.
ಲಕ್ಷ್ಮಿ ಮಾಧವಿ ಅಂದ್ರೆ D1, D2.
D2 and D3, my lord.
D2 and D3 exclude ಮಾಡಿದ್ರೆ
ಹೆಣ್ಮಕ್ಳು ಅಂತ.
Headmokku, married daughters.
One of the daughter, my lord, Vasanti.
And I will simply say 1/7 to everybody. ಏನ್ಮೂಲಿ ಅವರೇ?
That is what the interpretation given is, that the women are not family members as per the provisions of Land Reforms Act. That is why they are excluded ಅಂತ ಹೇಳೋ finding ಕೊಟ್ಟಿದ್ದಾರೆ first appellate court.
ತಪ್ಪಲ್ವಾ ಅದು?
The division bench judgment is sought to be canvassed by the first appellate court. I mean, that was not my line of argument, but anyhow, the first appellate court has its own interpretation. Page number 16, internal page number 16 of the first appellate court judgment.
ಯಾರಿಗೂ ತಕರಾರಿಲ್ಲ, ಕೋರ್ಟ್ಗೆ ತಕರಾರು ಅಂತೀರ ನೀವು ಹಂಗಾರೆ?
It gave its own interpretation saying that it will not inure to the married women. His Lordship Justice K.L. Manjunath judgment, division bench judgment.
How that in case of Vinita Sharma's case, ಎಲ್ಲ ಹೋಯ್ತಲ್ಲ ಅವೆಲ್ಲ ಇನ್ನೇನು.
And this is he contrary to his own argument.
Yes.
The fourth defendant has argued all family members equal shares.
Yes, yes. That was my contention, but first appellate court has given a different point.
To consider the following such a question of law. Whether the appellate court could have modified the decree and granted 1/14th share the plaintiffs and granted 1/10th share to the male members of the family. By consent, the appeal is also taken up for final disposal. These facts are not in dispute. One Balu Moili had a son called Rama Moili and daughter called Mamu Moili. Rama Moili was married to one Nagamma. No children, Allah?
Illa.
Illa.
ಅವ್ರಿಗೆ ಯಾರಿಲ್ಲ.
Issueless.
Out of this wedlock, they had no children. Mamu Moili, to her husband Venkat, had 5 sons and 3 daughters. One of the sons, that is Devdas, died without getting married. So consequently, Mamu Moili had 7 legal heirs, that is 4 sons and 3 daughters. Nagamma, the wife of Rama Moili, along with the 3 sons of Mamu Moili, instituted the suit for partition against the 2 daughters of Mamu Moili, D3 Yaro, and more than daughters, against
More
the 3 Mamu Moili and the remaining son of Mamu Moili. It was their case that the suit property was a tenanted property and the land tribunal had conferred occupancy rights in the name of Yarge,
Madhava, Devdas.
Nagamma, capital first plaintiff, and Devdas, the predeceased son of Mamu Moili. And this grant inured to all the family members. The trial court, in the light of the admitted relationship, in the pendency of the suit, Nagamma, the wife of Rama Moili, died. Thus, the only legal heirs of the propositors, Balu Moili, was the 7 children of Mamu Moili. The trial court, in view of the admitted relationship, came to the conclusion, the trial court, having regard to the fact that the suit property was a tenanted property and the entire family was cultivating the said land, granted 1/7 share to the sons, 4 sons and 3 daughters of Mamu Moili. That is plaintiffs P2, plaintiffs the second, third, and 4th plaintiff, and defendants 1 to 4.
Second plaintiff also has died, my lord.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕೊಟ್ರಲ್ಲ.
Please. Died at trial court itself, he died.
It may be pertinent to state here that the second plaintiff also passed away in the pendency of the suit, and his 1/7 share was granted to his legal heirs, who had been transposed as the fifth and sixth defendant. The fourth defendant, Chandrahasa, being aggrieved, preferred an appeal. The appellate court took the view that Bamu Moili, the daughter of Balu Moili, was entitled to 1/14 share, and Rama Moili, the son, was entitled to 1/7 share. The appellate court accordingly held that the children of Bamu Moili were entitled to 1/14 share. The appellate court also held that the male issues of Bamu Moili were only entitled to succeed to the share of Nagamma, and they were each given an additional 1/10 share. It is as against this judgment and decree, the present second appeal has been preferred. Admittedly, Balu Moili had only two children, that is Rama Moili and Bamu Moili. Rama Moili, the first son, had no children, and even during the pendency of the suit, his wife Nagamma, the first plaintiff, passed away. Consequently, the entire property would stand devolved on the legal heirs of the daughter Bamu Moili. Since Bamu Moili had 4 sons and 3 daughters, obviously all of them would be entitled to 1/7 share. In the light of the judgment rendered by the apex court, Vinita Sharma's case. The appellate court, however, has proceeded to hold that only the male issues of Bamu Moili were entitled to succeed the share of Rama Moili. This proposition runs counter to the decision of the apex court. Apex court's decision rendered in Vinita Sharma's case. So, since the entire property devolved only onto Bamu Moili, all her children would be entitled to succeed in equal proportions. The judgment of the appellate court cannot therefore be upheld. The subsequent question of law is therefore accordingly answered in favor of the appellants, and it is held that all the children of Bamu Moili would each be entitled to 1/7 share. The children of Bamu Moili who are no more, their branch would be entitled to succeed to 1/7 share. Second appeal is accordingly disposed of.
Appellate court judgment has to go, my lord.
Appeal allow ಮಾಡಿದಿನಲ್ಲ.
Much obliged.
Great.
I have said judgment of the appellate court is accordingly modified.
Please. Great.
Suit for
He admits that
number 17 alva.
he admits that he had entered into a agreement with his father on 8/6/1924.
8/6.
1994, 8/6/1994, he entered
Or plaintiff's father. Plaintiff. Plaintiff Basavaraj is the owner. Who entered into the agreement of sale? That is N.S. Krishnaya.
So he then states in the play, necessity did not perform. So I terminated the agreement and forfeited the advance paid towards damages. Said the agreement was not produced, neither were the notice of termination nothing is produced. We confront the agreement of sale with partners exhibit D. Then he takes up the package. Oh, this is not the agreement. There is one more agreement which is Canada.
So according to you also, your only claim towards properties on the basis of the agreement of sale.
Yes.
Then how can you resist this prayer for declaration? You admit title is not with you.
What happens? He executes a power of attorney in favor of first defendant. Basavaraj.
When?
Power of attorney, exhibit D13, he executes power of attorney. Same thing.
8/6/94.
Power of attorney, D13. 8/6/1994. It is executed and admitted before a notary.
This is N.S. Krishna as executed. GP, who was executed the GP?
Because his father had said.
In favor of D1.
His father had said, he on my nominee is given that this salary nominee. Then what happens? D1 executes the sale in favor of his wife, who in turn executes the sale in favor of D4 also. Then what he does, he files the suit, asking for a declaration that he is the owner of the property. Declare that the sale is executed by D1 in favor of D4 and the sale to D4 is null. He doesn't ask for any declaration that the power. Then what he does, he files his claim. He signs only in Kannada. This is one I only signed in Kannada. We produced a document to show that the sign in English. The trial court gave no fight. That no one is scoring that he does not know, he does not sign in English, cannot be believed. What now remains is that both parties did not apply for indemnities. The trial court said you did not apply for handed, though they were admitted documents. The trial court said you did not apply for handed, therefore you are not to pay for it. But in fact, there is one judgment of the court says it's a criminal case, which is 73 judgment says that court has power to serve. Even if the parties don't ask for handed experts, it will be a court to compare. But then parties can't complain that the judge is not present. This is
No, your case was that an agreement of sale was executed in your favor, independently, not with reference to any agreement of sale.
agreement of sale is where my father and the number my father died.
No, that agreement of sale is not enforced, therefore you claim no.
The power of attorney is given to the respect to the same property.
No, agreement of sale is in favor in the name of the father. GP is the name of the son.
The father said, I was getting old, you GP and your person, I quickly execute the sale in purpose. They have received the entire sale consideration of finance. All those receipts you said in English. Files the suit.
Both the courts held that the GP has not proved.
What is that? Because the GP having been executed for presumption of the evidence side. The court says, no, you're not exactly attesting. But there's a legal presumption. It is properly executed by Basavaraj. Court could not have come to a conclusion that no, you are not exempt. If some other evidence had been produced by the plaintiff, because the plaintiff's only defense is, I don't child in English. All we said was, if the trial court had compared the signature B12 and B5 or B13, they're so clear. We came to the first appellate court. Produce this judgment. First appellate court notices the judgment. And
You were aware of the fact that the agreement of the GPA was not admitted by him.
no, he says it's not mine.
Then even then you chose to take the risk of not referring it to the,
I agree, but
and what can you do?
we see this.
Oh, you took a chance.
No, right?
Took a chance. Therefore,
Why when the Supreme Court says, Supreme Court says, this is
so now the burden is upon the court to establish that it is a signature when both of you are not interested in proving the execution.
reading of the judgment. What else? Well, so this is independent of the case, such a case. The argument that the court should not mention the right itself, as thereby assume to itself the role of expert, is entirely without force. Section 73 of the Evidence Act especially enables the court
So that was a case in which the court had examined the document. The court frowned upon the.
You see, there may be cases that both sides are experts. There may be cases that neither side was an expert. The duty, duty cannot be avoided by a close statement that the court is not expert. When there are expert opinions, they read the court. When there is none, the court will have to seek guidance from the authority to the court's own experience in the discharging process. It's made without the expert, without other evidence. But this, what happens is it's a procedure. Today, here is a man who deliberately signs in Karnataka.
You are aware of that. You chose not to take the steps to discharge the burden. Your entire claim was on the basis of agency created in your favor. You don't establish the agency created in your favor in a manner known to law.
Just enjoys a presumption. I agree. No, but the reason is not that it's not. Reason is you are not accepting attesting. See the trial court judgment.
Had you examined somebody to show that the
I have this presumption 85. I don't need to accept the person who was cited as a witness forward on it. If it is executed in the presence of the law, executed and it is presumption. So he will have to show that he was not there on that day. Something that he has not done anything except saying no. Court also
burden is entirely on you, Mr. How can you shift it on the plaintiff to say, how can he prove the negative? How can he say that the signature found is not on his? Once you say that this gentleman signed.
signs in English.
No, you knew this gentleman was not trustworthy. You need to have taken steps. Without that,
Steps are not taken. The point is whether court says 73.
this was a case in which the court had taken. This was a case in which the court took upon itself to compare the signature. Then an argument was advanced that you cannot do it. Then the court said, no, it is a duty.
Looking at the two documents and saying that this is because the court comes to the conclusion it's not signs in English. I agree. The court has said no, there is no evidence in signs. Signs in English.
It's a finding of fact recorded by both the courts. The GPA is not executed.
Not finding of fact. The court has not exercised power in the stream, and therefore the result will just come out.
Your argument appears to be that whenever the signature is in doubt, it becomes a duty of cast on the court. If it's not done, if the execution is not proved, nevertheless, the court should sit upon.
Look at it and say, no, I don't agree. It is not
What has it said about the execution of the agreement? The trial court, what has it said about the execution of the agreement?
He said it's not true because
Where is, which paragraph?
I vote. It's not true.
Then property, no?
Please see page 130 of it shows that PW1 is accepted as per
No, the finding of the trial court, which paragraph?
Please come to page 130. In page 18. Please see this. Please see this page. Paragraph 14, page 129. It's pertinent to note here that the plaintiff has admitted in his pleadings.
Where are we reading? Paragraph 14. It is on a.
It's pertinent to note that the plaintiff has admitted in his pleadings that he has executed the agreement of sale at 8628 and in favor of the defendant with respect to suit schedule. During cross-examination, the agreement of sale is not executed. Yes, it has executed, not executed. But he has executed another agreement of sale was the execution, not produced, not. Because the contention which is based upon.
The agreement of sale has no bearing. You had to prove the execution of the GPA.
Arising out of the agreement of sale, he executes the power of the same day. Then if the lordship comes to the end of the page or next page, it says in such circumstances, the contention is not allowed to the plaintiff. That the plaintiff used to make his signatures, the plaintiff does not say the signatures this cannot be accepted. On the one hand, it says yes, make signatures use. He says that the exhibit people is the is the admission made by the state that is the finding of fact that he has executed his people. Then he says it is my duty to execute people. I enter into the witness box. I say this is the signature of the people. That portion of the diagram.
Where is the finding regarding the GPA? Which paragraph? Because if your father did not choose to enforce his agreement of sale, when was the sale deed executed? In favor of your wife? After the suit was filed or before? When?
Much before the suit was filed and executed, they are in possession of the property.
2004.
Sale deed dated 7/20/2004 and 16/20/2005. 7/20/2004 executed by me. 16/20/2005 second.
What is a GPA exhibit? B13.
Coming to the GPA, para 18 page 138. But in the sale agreement, there is a recital about this. Defendant number 1, P5, this reference is what the type of holds. Please note, it's pertinent to note that data goes to the careful pronunciation power of respect. But the plaintiff is denied its power. But currently means that if the side not chosen to examine. Therefore, it says nothing this also stops. This is not. My only solution is this, but there's a presumption in favor of pure execution. That to be displaced. Some evidence, no evidence, no evidence.
The trial court has doubted the very exhibit D5 and D13 at paragraph.
No, he said two stamp papers are purchased, handed in the assistant of Akunta Avunu is what people do not have important stamp pattern, popular stamp pattern, it's the work of that. So that can't be, but this, but 85 has to be equal some.
This is essentially an appreciation of evidence by the trial court. It has found.
My submission is.
The fact remains that you did not pay the entire 5 lakhs on the day of the agreement of sale.
No, after
If-
you pay, actually B7 to B11 are receipts, but she has received and
No,
signed.
but the agreement of sale, what did it recite? That the entire sale consumption was paid on the same day.
No, only 1 lakh 5,000, that he admits. But then the plaintiff says, I have only paid for damages.
So let him say whatever he wants to say. But what does the agreement?
He says, I have paid 1 lakh and 5,000 rupees on the date of agreement.
Do you have a copy of the agreement of sale with you? Records money. GPL is I have my doubts about this agreement of sale. All for records.
Because here the man hasn't come with 3 months.
The agreement of sale does not contain the name of the stamp vendor. I don't think. I saw both of them. Both of them don't have the stamp vendor's name. So I have my own doubts as to. Let us see. All for records. Phone number. Uh, 2 weeks time. It is stated that respond number 21 is no more. 2 weeks time is granted. 2 weeks time is granted to take steps. Yes.
And also alternate clear from the clearly saying that in the alternative the court wants to declare grant relief from declaration. Direct them to execute this agreement as per the earlier there was a compromise between the father and father.
What was the declaration based on?
Based on the compromise decree.
Compromise decree passed in?
Compromise decree passed in OS 34 of 34 of
This was filed by whom?
The required number 34 of 24 was filed by the father of the defendant, first respondent. For the movement city.
R1 andre R1 andre plaintiff. Plaintiff. In favor of? Against?
Against the respondent of the full case.
Yaru? Father rail on father of D1. Suit was for?
Blood certificate of the relief of redemption of mortgage. 1996, mortgage registered mortgage of mortgage was executed. Wherein below the subject matter of
What is the date of the mortgage?
19 mortgage for in the year 1966, mortgage was
Date.
dated below 15/4/1966.
This was by whom? This was by?
This was executed by plaintiff's father, Uganda City one.
In favor of father of defendant number 1. This mortgage was sought to be Nagidava 34/84.
Where blood they filed joint composition. The terms of the composition are different. Out of 20 because has to be given to the plaintiff's father. And the remaining 21 because has to be given
20 guntas is to be
father of the plaintiff.
given andre ಏನು?
Because out of 1 acre 1 because he has to relinquish his claim in respect of remaining 21 because 1 acre 1 because. 20 because to the plaintiff father, 21 because to the plaintiff father.
ಅಂದ್ರೆ ರೀಕನ್ವೆ ಮಾಡಬೇಕು.
Yes.
21 guntas was agreed to be sold to D1. But no registered sale. This compromise was not registered. Then
What happened that thereafter, the father's post dependent father was paid. But the possession was with the dependent father only. Can extend down.
ಆಯ್ತು, but you're only what mortgage all the time. How can you become owner?
As per the compromise.
How can the declaration be denied? How can the declaration be denied?
The credit court will not there before the court for exchange of mortgage cash. Declare that they are owners of the property. But the dependent number 1 father has sold the property to the dependent number 2. But under the register he is in possession.
If defendant ga
Yes. You have the dependent number 2. You have the subsequent purchaser.
right of preemption ಬರುತ್ತಾ?
Alternative prayer is not for the right to.
ಬರುತ್ತಾ ಆತರ?
That's why section 14 is very 40 of the credit court, the first complaint court has complained conclusion. As per section 15B of the Justice Relief Act, the contract between the
Issue notice.
here you are seeing that the right page.
There should be an interim stay of impugned decree for a period of 8 weeks.
And there was a delay of 3 years, 9 months between the file. That time without evidence. Procedurally, the
3 years, 9 months ಏನು?
evidence in the hearing and I am especially
Where is your application?
As per section 5 of the education Act, each and every day delay twice to be explained.
Now, what is the reason given by you? Reason ಹೇಳಿ ಅವ್ರು ಏನಾರು ಇಟ್ಕೊಳ್ಳಿ. FD5 FD what is there on merits for you to content? What is the relationship? Like merits ಮೇಲೆ ಇದ್ರೆ ತಗೊಳ್ಳೋಣ ಸುಮ್ಮನೆ ಯಾಕೆ why do you want to keep this appeal pending? Mayama is the first plaintiff. You are Basavaraj. Then what was granted by the trial court?
My contention is that she was starting from both of them.
ಎರಡು sister one brother mother was also alive. Mother was alive.
No, yes, nobody was alive. Only sister. She is my sister.
Mayama.
Mayama is my sister. And Jyoti and Shanta is a sister. Another sister. And since they were the death of them, they sued my name of this issue. And they
ಆಕ್ಚುಲಿ ತಪ್ಪಲ್ವಾ ನಿಮ್ಗೆ ಜಾಸ್ತಿನೇ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲ ಇವಾಗ ಅಲೋ ಮಾಡಿ ರಿಮೈಂಡ್ ಮಾಡ್ರೆ ಕಮ್ಮಿ ಆಗ್ಬಿಡುತ್ತೆ ನಿಮ್ದು. The appellate court has refused to condone the delay of 3 years 4 months filing the appeal and has dismissed I number 1. Consequently, the appeal. Admittedly, the suit was decreed on 13/3/2018 and the appeal was filed. Page number 29. ಹತ್ರ ಅದು ವಾದಿ ವಿಭಾಗ ಮತ್ತು ಪ್ರತ್ಯೇಕ ಸ್ವಾಧೀನ ಕೋರಿ ಸಲ್ಲಿಸುವ ದಾವೆಯನ್ನು ಭಾಗಶಃ ಡಿಕ್ರಿ ಮಾಡಲಾಗಿದೆ. 1ನೇ ವಾದಿ ದಾವಾ ಐಟಂ ನಂಬರ್ 1 ರಿಂದ 4ರಲ್ಲಿ ಆಸ್ತಿಗಳನ್ನು 1/4 ಎಸೆ ಹಾಗೂ ಪ್ರತಿವಾದಿಯು 3/4 ಅವ್ರು ಕೇಳಿರ್ಬೋದು. ಬಟ್ actually duty is cast upon me to enlarge the share. ನಾನು ಜಾಸ್ತಿ ಮಾಡ್ಬೇಕು ಆಕ್ಚುಲಿ ವಿನೀತ್ ಶರ್ಮಾ ಕೇಸ್ ಅಂತ. ವಜಾ ಮಾಡಿದ್ದೇನೆ ಬಿಡಿ ಸುಮ್ಮನೆ ಯಾಕೆ. The appeal was filed on 5/10/2021. That is after a period of 3 years. The only contention put forth regarding the delay was that the appellant was suffering from jaundice and he was taking treatment from a native physician. And also, it's a hospital. The appellate court has found that the reasons offered for the delay were unacceptable. And there was no document to justify the inordinate delay, to condone the inordinate delay of about 3.5 years. In my view, the trial court has correctly rejected the application for condonation of delay and also the appeal. I find no reason to retain this second appeal. Consequently, this second appeal is also dismissed. Then office objection, the appeal is being dismissed. The insistence on the office objections would not arise. Without to continue.
Lord, may I make a submission, my lord?
Next Monday. Next Monday.
My lord, may I make a submission, my lord?
1 minute. 24. Really? 1 week to complete those. Yes.
Serial number 29, my lord. I have filed impleading application. The office has raised office objection stating that I have not mentioned full cause title. A week's time may be granted, my lord.
1 week.
Highly obliged, my lord.
Serial number 37, my lord.
Of office objections, 1 week. Indian application. It is also stated that an application is filed by the council of the applicant office to verify. And if an application is filed, the same to be.
Serial.
ಎಮರ್ಜೆನ್ಸಿ ಇದ್ದವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ ಎಂಟ್ರಿ ಮಾಡೋದು ನೆಕ್ಸ್ಟ್
Court officer? Court officer?
Court officer? Court officer? Court officer? Court officer, Court officer. Court officer.
லாஸ்ட் முடிச்சுருந்தா திடீர்னு வந்துடும் ரொம்ப பார்த்துக்கலாம் ஃபியூச்சர் வேணாம் இப்போ நான் சின்ன அது வேலை பண்ணிருக்கேன் போச்சனப்பா நம்பர் பிளேட் இல்லப்பா நீங்க ஒரு பைசா கொடுத்தாருன்னா நான் வந்து நம்பர் பிளேட் வீட்டுல கல்வி பண்ண ஏன் கட்டுரை ரொம்ப டாக்ஸ் போடுறோம் இது வேண்டாம் நாளைக்கு மட்டும் நைட்ல Reset ಮಾಡಲ್ಲ
Court officer. Court officer.
Court officer.
ಕೋರ್ಟಲ್ಲಿ ಹೋಗ್ಬಿಡ್ತೀನಿ ನಾನು.
Court officer, list 2, serial number 11.
Definitely I did, I have to do. Okay. You come, once and go. Oh, yeah.
Court officer, serial number 2, serial number 11.
I didn't do that.
ಈಗ ಯಾಕ್ರಿ ಹಂಗ ಬರಾಕತೈತಿ ಲೈವ್ ಯಾಕಿದೆ
Court officer.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ
ಹೇಳಿ ಸರ್.
ಆಡಿಬಲ್ ಇದೆಯಲ್ಲ?
ಹಾ ಇದೆ.
Court officer, serial number 11, cause list 2. Court officer.
Hello, court officer.
Hello, court officer.
Hello, court officer. Hello.
ಲೈವ್ ಸ್ಟ್ರೀಮ್ ಅಂದ್ರೆ ಏನು?
ಅದೇ ಸರ್ ಯೂಟ್ಯೂಬ್ ಯೂಟ್ಯೂಬ್ ಅಲ್ಲೆಲ್ಲ
Court officer.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಒಂದು ರಿವ್ಯೂ ಪೆಟಿಷನ್ ಇದೆ ಈಗ, ತಗೋತಾರ? ಸೀರಿಯಲ್ ನಂಬರ್ 2.
ಧಾರವಾಡ ಮಠ ಸರ್ ಬರ್ತಾರೆ ಸರ್ ಈಗ 2:30.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್. ಸೆಕೆಂಡ್ ಅಲ್ಲಿ 11th ಸೀರಿಯಲ್ ನಂಬರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ ಎಲ್ಲ ಬೇರೆ ಬೇರೆ ಇಲ್ವಾ?
ಇದೆ.
ಮತ್ತೆ
73/32 ಎಲ್ಲ ಹೇಳ್ತಾರೆ.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಬರುತ್ತೆ.
ಏನ್ ಮಾಡಿಲ್ಲ?
ಎಮರ್ಜೆನ್ಸಿ ಇದೆ, ಇದರಲ್ಲಿ ಸ್ಟೇ ಬೇಕಾಗಿತ್ತು, ಅದಕ್ಕಾಗಿ. ಕೊಡಲ್ಲ, ಆರ್ಡರ್ ಆಗ್ಬಿಟ್ಟಿದೆ ವಾರೆಂಟ್, ಅದಕ್ಕೋಸ್ಕರ ಇನ್ನೇನಿಲ್ಲ.
ನಾವು ಬರಲ್ಲ. ಆಫೀಸ್ ಇದೆ ಅಲ್ಬೇಕು.
ಸಂಜೆ ಬರ್ತಾನೆ ಈ ಬೈಕು
ಏನಾಗಿದೆ?
ಸರಿಯಾಗಿ ಇಲ್ಲೊಂದು ಸ್ಪೇಸ್ ಇತ್ತು, ಇಲ್ಲೊಂದಷ್ಟು ಅಲ್ಲೂ ಒಂದು ಅಲ್ಲೊಂದಲ್ಲಿ ಕೇಸಿಂಗ್
ಮೊದ್ಲು ಹಾಕ್ಸಿದ್ಯಾ?
ಕುಮಾರ ಹೇಳಿದ ಪ್ಲಾನ್ ಅದು. ಏನು ಮಾಡಿಲ್ಲ, ಏನೋ ಮಾಡಿಲ್ಲ.
ಕುಂಬಾರ್ ಸರ್ ಮ್ಯೂಟ್ ಮಾಡಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಸರ್ ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಸರ್?
ಸರ್ ಇದೆ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್, ಇದ್ಯಾಕೋ ಎಂಟ್ರಿ ಕೊಡ್ತಾ ಇಲ್ಲ ನಮಗೆ? ಧಾರವಾಡ ಮ್ಯಾಟರ್ಸ್ ಇವತ್ತು ತಗೋತಾರಲ್ವಾ ಸಾಹೇಬ್ರು?
ಹೌದು ಮೇಡಮ್, ಬರ್ತಾರೆ ಬಂದ್ಮೇಲೆ 2:30 ತಗೊಂತಾರೆ.
I have 3 more admission matters. After that, I'll come to Dharwad bench.
Admission matters after. Please.
Number 21, Arjun.
My lord, cause list 2, serial number 11.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಹೋಗಿದೆ ಸರ್.
ಇಲ್ಲಿ ಎಮರ್ಜೆನ್ಸಿ ಸ್ಟೇ ಬೇಕಾಗಿ ಸ್ವಾಮಿ, ಹಾಗಾಗಿ
ನೀವು ಕೇಸ್ ಕಾದಾಗ ಇರ್ಲಿಲ್ವಲ್ಲ, ನಾನು ಏನ್ ಮಾಡ್ಲಿ ನಾನು. ನೆಕ್ಸ್ಟ್ ಮಂಡೇ
ಮಚ್ಚವ್ರೆ.
ಅದೇ ಲಿಂಕ್ ಅಂತ
there is a schedule. Key properties. Where is it mentioned about the roadway in this schedule? Because this talks about arrest number 270/1B. Put 3 portions: middle portion, middle portion, middle portion. Where exactly is the property then? Where is the roadway according to you? It's the state of arrest 270/1B. Against what is the defense? Apart from the eastern one. You have the report? I will look at it. Did they prepare a sketch? It refers to a plain sketch. You have a copy of the plain sketch? Plain sketch.
ಚಾರ್ಜರ್ ಕಡೆ ಮತ್ತ 230ಗೆ ತಗೋತಾರ ಅಂತಂದ್ರು.
only rule.
Also records both the parties to maintain status quo the next date of hearing. Time or a time killer bedige respondent gave it responsive. I told him that I'll ask you, and then if you have no objection, I'll adjourn. Mr. Shetty?
Yes, my lord.
Urgency the Akol Monday.
I'm appearing for the.
He says he hasn't got the copy of the. Already there. Shetra.
Let them argue, my lord, but ನನ್ನ problem ಇದೆ that records ಇಲ್ಲ ನನ್ನ ಹತ್ರ ಮತ್ತೆ KV to return ಆಗಿದೆ. I have to comply with office objections. ಅದಕ್ಕೆ ಮಂಡೇ ಹಾಕಿದ್ರೆ will both of you can argue them.
Monday. In the proper ಇದು.
Say. Prospect the appeal. Page 29.
Suit is for?
Suit is for declaration and injunction. Genealogy. Page 29.
Yes.
ಹಿರಿಯಪ್ಪ ಪೂಜಾರಿ ಅವನಿಗೆ 2 ಜನ ಮಕ್ಕಳು, ರಾಮಪ್ಪ ಪೂಜಾರಿ, ದೇವಪ್ಪ ಪೂಜಾರಿ. ಅವರ ಪ್ರಕಾರನೇ there was a partition in the year 1930 between the two brothers. The two property fell to the share of Ramappa Pujari. ಇವರು land revenue ಕಟ್ಟಿಲ್ಲ ಅಂತೇಳಿ it was treated as after about 1943. Then it was brought to auction. Auction ನಲ್ಲಿ ರಾಮಪ್ಪ ಪೂಜಾರಿ 53 ರಲ್ಲಿ auction ನಲ್ಲಿ ತಗೊಳ್ತಾರೆ.
1953.
ಅಲ್ಲ 53 ಗಿಂತ ಮೊದಲು 1953 ರಲ್ಲಿ he surrendered the occupants in favor of Ramappa Pujari under the 1888 land revenue code. That's a provision. ಈಗ ಕೋರ್ಟ್ ನಾವು ಏನಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ ಇದು ರಿಜಿಸ್ಟರ್ ಆಗಬೇಕಿತ್ತು, ಈ ರೀತಿ ಸರೆಂಡರ್ ಲಾ ಮಾಡಿ ಹೈಕೋರ್ಟ್ ಡಿಸ್ಮಿಸ್ ಇತ್ತು holding that there is surrender, possession, etc. all those things. Appellate court reverses it on the ground that it is not a registered deed. Model. ಎರಡನೇದು, it is there evidence in the chief extent that present appellant as is in possession of the property. He has done the borewell.
Where is it?
Finally, go to page 93. High Court judgment, page 93, paragraph 49.
Yes.
Paragraph 39. PW1 has also admitted that on 33/2009, social property was sold by Hemantappa and wife Hirappa and his children to meet family expenses. Further, in page 10 of the cross-examination, PW1 has unequivocally admitted that after the purchase of the property in 2009, dependent number 5 is cultivating the social property. She has denied the suggestion that she does not have a personal matters. Then, party. PW2 Mutappa is an appendix of the parties to the suit. He has stated that since 65 years, he was cultivating the food sharing property. On his, he was giving crops every year to Java. After the death of Java, Prasappa and the property, he was cultivating the food sharing property on his. After the death of Perception, relative has received the property. He has continued to live. Further, he proposed that KP Rudragowda, that is the appellant, stated that he has purchased the social property and dispossessed him of the property.
I'll maintain status quo.
We'll make an application for that.
Maintain status quo. For this matter. Next Monday hakolla. Next Monday.
Yes, ma'am.
Next Monday hakolla ಪರವಾಗಿಲ್ವಾ? ಇಷ್ಟಿದೆ ಆರ್ಡರ್. He weeks to comply with the office instructions. One week to comply with the office instructions. Confirmation.
In this case, I am appearing for the respondent, madam. In both the cases, I am appearing. According to me, it is covered by the judgment of Aminita Sharma case.
ನೀವು ಯಾರಿಗೆ? ನೀವು? One week to do the needful.
IAPF respondent 1 and 2.
1 week to do the needful.
Much obliged.
2 weeks.
Appear for respondent. Respondent number 10.
2 weeks to.
ಹೇಳಿ ಸರ್. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಇದೆಲ್ಲ ಇದಕ್ಕೆಲ್ಲ ಏನ್ ಮಾಡ್ತೀರಾ? ಮೇಂಟೆನೆನ್ಸ್ ಎಲ್ಲ ಕೊಡ್ಬೇಕಲ್ಲ.
In this case, 31, I am appearing for the appellant, my lord.
Yes.
My lord, this case, your lordship last night of hearing directed me to file the affidavit of other sharers, other heirs. And I filed all the 4 persons affidavit heirs, an affidavit. And also filed a memo to that effect. All the 4 heirs have said no objection to continue by respondent appellant number 2. All the 4 sharers, other sharers.
ಏನಕ್ಕೆ ಬಂದಿದೆ ಇವತ್ತು?
ಅದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೆ ನಾನು, ನಾಟ್ ನೆಸೆಸರಿ ಅದ, ತಾವು ಅಫಿಡವಿಟ್ ಹಾಕ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ರಿ, ಮೆಮೊ ಹಾಕೋಕೆ 4 ಜನದ ಅಫಿಡವಿಟ್ ತರಿಸಿ ಹಾಕಿದೆ. ಅಂಡ್ ಆಲ್ಸೋ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಒಳಗೆ ಅಡ್ಮಿಟ್ ಆಗಿದೆ, ಸ್ಟೇನು ಕೇಳಿದ್ದೇನೆ.
In connected matter, I appear for respond.
This is the only case of for reference only. I am ready for that. Court has admitted the appeal, the questioning.
What is the objections, office objections?
Office objections, no, this I filed an application because the court said you bring all the LRs. Therefore, I filed an affidavit of all the persons who other has. And now, there is no office objection regarding recalling the order. I sought for recalling that order, but your lordship, unless you produce it, that I have produced it now. Memo for the affidavit.
ಎಲ್ಲ ಹಾಕಿದ್ರೆ ಅಫಿಡವಿಟ್
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೇನೆ, ನಾನು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೇನೆ. 1/2/22 ನಾನು ಸಪರೇಟ್ ಮೆಮೊ ಹಾಕಿ 4 ಜನದ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೇನೆ. 1/2/22 4 ಜನದ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೇನೆ. 4 daughters.
on 22/10/2021, the request of the council for the appellant to bring the other, that there was no need to bring the other legal representatives on record was rejected. And it was stated that if there are any other legal representatives, they ought to be on record. The counsel for the second appellant claims that there's a will executed in his favor. He has filed a memo along with the affidavit of Yaryaro?
4 daughters. Those are other
Along
heirs.
with
Srimati Neelamma, Renuka,
affidavit of Neelamma, Renuka Gowda, Nagaratna
and also
and
Srimati
Shobha C, who according to him are his sisters, and apart from him, they are the other legal representatives of the first appellant. In the affidavit, all these sisters of the appellant have stated that they have no objection in considering the appellant as the legal representative of the deceased first appellant and to prosecute the appeal. In view of the said affidavit, there would be no need to bring the other LRs of the deceased first appellant on record. So this order is over, made subject to the ultimate decision.
Yes, sir. Amendment, I will do it, carry it out, madam. Amendment, madam. But my application for stay also, the reason is there are connected matter. The question before this, we may submit, madam, if the court permits.
What is the connected matter and what is this?
What happened is,
who appears in the connected matter?
IAP of the respondent one.
It's
my
already
lord.
admitted. It's already admitted.
It's already admitted. my lord.
Is there an interim order in that case?
No, my lord.
Other question, because only shares for the here is the state because they have filed affidavit FDP proceeding. I produce a copy of FDP proceeding also along with this. Along with my I produce the FDP proceeding also.
No, is it against the same judgment that this appeal is also?
No, my lord.
Shares forget same judgment are the same shares. That's what only the shares are just one and the same. While they with respect to other property, one
notice ಹೋಗಿ ಬರಬೇಕು.
Other notice over. I do consider that is no question. You are correct. I am not disputing it. The question is they have already initiated FDP proceeding. Therefore, I filed a stay application.
The admission argument ಮಾಡಿ next week ಆಮೇಲೆ ಕೇಳ್ತೀನಿ.
I am ready. But also, if the court permits, I am ready.
Post for admission next Monday. Two weeks. The council submission regarding a discrepancy in the name of the father of the first plaintiff is accepted. Two weeks.
Lord, I have filed 2 applications, my lord, on 28th January. Lord, in compliance of the office objection, my lord.
Non-compliance anta ide.
Lord, I have filed 2 applications, my lord.
In the applications, my lord, that office raised an objection that there is no specific prayer. ಅಯ್ಯೇ prayer specific ಇಲ್ಲ.
ಎಲ್ಲಿದೆ ಅಯ್ಯೇ ನಿಮ್ದು?
Lord, application is filed by the appellant, my lord.
ನಿಮ್ದು application ಕುಮಾರ್ರೆ?
ಅಲ್ಲ,
application is filed by the appellant. R1 is expired.
Office objection.
Rarely setting aside abatement.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಡಿ ವಿಶ್ವನಾಥ್. ಸೆಟ್ಟಿಂಗ್ ಅಸೈಡ್ ಅಬೈಟ್ಮೆಂಟ್
ಹಾಕಿದೀನಿ 28ನೇ ತಾರೀಕು ಹಾಕಿದೀನಿ.
ಪುಟಪ್ ಆಗಿಲ್ಲ.
ಹಾ ಅದೇ.
Stated that the office objection is complete with office to verify. Ajeshwara. It's the last chance. 1 week's time is granted to comply.
I appear for the appellant.
From 2019, it was granted to you. 3 weeks was granted to you.
Maharaj, 3 days time may be granted. Maharaj, I'll comply with the office objection.
Next week, if it is not done, it will be dismissed.
Please, I'll comply. Great.
For respondent number 2 weeks. In view of the endorsement of refusal by R10 and R11, notice to them is held sufficient. File a memo.
Appellant, my lord, short 1 week time may be granted for complying the office objection.
1 week.
I'm appealing for the appellants, my lords, in this matter.
Yes.
My lords, in this matter, respondent number 2, 13, 17, and 23rd are no more, my lords. I have filed an application regarding that.
Now, first one you have to take out, you have to pay process fee for R2, R7 to R10.
Please, my lords, R2 is no more.
R2.
Please.
You made an application for bringing the LS on record?
Please, my lords, I have made the application.
When?
My lords, it's on 2nd August 2021.
It stated that an application to bring the LS of R2 on record has been filed on. When did you file it?
My lord, 2nd of August.
2nd of August 2021. Office to verify. 2 weeks time to comply with the remaining office objections.
Lord, 41.
Yes, 41.
Lord, regarding the name of the 14th defendant, Lord, you also kindly see the page 69. Ink page 69. Ink page 69.
First objection is first objection is name of respondent number 1 in RSA.
Yes, my lord.
The appellant in RA is treated as Munipapamma.
Yes, my lord.
Whereas in the cost title OS name is treated as Papamma.
Papamma, my lord, you also kindly see page 69, my lord. Page 69. 14th defendant.
Yaro?
14th defendant, Papamma.
No, Papamma.
CA only filed the appeal. You will also kindly see the page 17. RA.
Munipapamma daida.
See the same, my lord. You will also kindly turn. Page 22, my lord.
It is stated that the 14th defendant and Munipapamma, the appellant, in RA 100/17 is the same. Instead, submission is accepted. Next,
Second objection.
defendant number 13.
Yes, my lord. You will also kindly see the page 22, page 22, my lord.
Page
22, my lord. 22. RA.
Yes.
There are two, my lord. So the take up amendments for rank of the party is referred to.
In RA, the appellate court has noticed that the 13th defendant with the trial court had died living behind no issues. So counsel submits that in view of the above, he is not been made a party. So the said submission is accepted.
My lord, order to post admission, my lord.
For admission next week.
The date may be
next week, Bharat.
Oh, please.
Right now, first,
ನೀಡ್ಫುಲ್ ಮಾಡಿಲ್ವಾ ಹಂಗಾರೆ ನೀವು? ನಾನ್ ಅರೇಂಗ್ ಆಫ್ 3 ನಾನ್ petition copy or any relevant copy in FDP to be filed for verification of cost data. Individual rank of parties to be stated. I for CD to be not pressed. Either petition copy or any relevant copy. ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ? ಎಲ್ಲರನ್ನು ಪಾಡಿದಿರಾ? ಇದು ಯಾರನ್ನ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ? R9 R9 ಹೆಂಗ್ ಬಿಟ್ಟಿದ್ದೀರಾ? ನಿಮಿಷ R9 ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಯಾರು? Since the suit was dismissed as against R9, the submission of the counsel that he was not made a party in the RA is accepted. Await service of notice in respect of R4C and D, R5B1 and R5C2. Then non-filing of acknowledgement by advocate for affidavit. ಯಾರಿಗಿದು? ಯಾವತ್ತು ಹಾಕಿದ್ರಿ? It is stated that the acknowledgement for having sent the copies by register post has been filed on 7th, office to verify. Next week. ಯಾರಿಗೆ? ಇಲ್ಲ in view of the acknowledgement indicating service of notice on the counts for the caveat, the office objection in that regard stands complied with. Post for admission. Remote granted earlier shall stand extended. Post for admission next Monday.
Not in this matter, I got a submission to make. But in so far as the second appellant is concerned, not her name is Sumita, but in the Wakala she has filed as Sumitra. Not office has raised an objection.
Second appellant.
Second appellant. Sumita anta ide. Wakalathali Sumitra anta madi. Therefore, I have offered an explanation that it pertains to the same person. Sumita and Sumitra are pertaining to the same person anta I put up office note.
Submits that the second appellant, though named Sumita, has signed Wakalat as Sumitra and the same may be accepted.
And it's
Request
so
to consider the
ಡಿಫೆಂಡೆಂಟ್
Defendant
ನಂಬರ್
number 8
8
ಏನು?
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 8 ಅಲ್ಲಿ ಅದು ಸುಮಿತ್ರಾ ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮತ್ತೆ ಅಪಲೇಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ಆದ್ರೆ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸುಮಿತಾ ಅಂತ ಬಿದ್ದೋದು. Your Lordship could see not internal page 78
that in the trial court, a defendant was described as Sumitra, whereas in the appeal, she has been described as Sumita. Counsel submits that her correct name is Sumita. The said submission is accepted. The 8 defendants can be treated as a person called Sumita.
One more submission I would like to make.
Yes.
After filing the appeal, the second appellant has died. And I filed an application on 27/1/2021 along with the death certificate to bring the LRs on record of the appellant number 8.
ಯಾವತ್ತು?
She appellant number 8 died on 7th January 2000.
When was the application filed?
27/1/2022.
Appellant number 8.
ಹೌದು, ಚಿಕ್ಕನಾರಾಯಣಪ್ಪ.
The application filed to bring the LRs of deceased 8th appellant as appellants 8A to H is allowed since the right to sue survives. Cause title to be amended.
One more submission. The matter has been settled between the parties. That is why I moved a memo before this honorable court. Even compromise petition is prepared. But however, at the time of preparing the compromise petition, it was noticed that 2 of the family members have been inadvertently left out from the proceedings. Therefore, my lord, an impleading application has been filed, my lord, by a third party, asking her to come on record, my lord, because those are the 2 persons who have been left out in the proceedings before the court below. I have got no
lawyer. ನೀವೇ ಹಾಕಿದ್ರಲ್ಲ?
ಇಲ್ಲ ಅವರೇ ಹಾಕಿದ್ದಾರೆ. There is an impleading applicant, my lord, by advocate by name BV Acha.
By Minilakshi and Sudhamani to come on record as R17 and R18, contending that they are also family members and they are required to come on record. This application is not opposed by the counsel of the appellant. Hence, A2/22 is also allowed. Cause title to be amended in this regard also.
A date not to report compromise.
ಯಾವತ್ತು ಮಂಡೇ ಹಾಕೊಳ್ಳ?
ಈ ವಾರದಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಕೊಟ್ರೆ I can get it.
Thursday. 17.
Lord, office objection is, my lord, the name of the one of the respondent herein, that is, my lord, respondent number 5. Lord, in OS, my lord, OS, page number 91, may kindly see, my lord. First of all, his name was mentioned as Siddharaju, my lord, as defendant number 5. 91 is the judgment of the OS. And 92, may kindly see, my lord, defendant number 2.
Defendant or
D5, my lord. Siddharaju. Lord, may kindly see, my lord, page number 20. Lord, suffering the judgment and decree, he preferred an appeal. Page number 20 may kindly be seen, my lord, loyal appellate court judgment. He himself, my lord, filed an appeal challenging the judgment and decree, and his name is shown as Siddharamu.
The 5th defendant was described as K. Siddharaju. So, Learned Counsel submits that the said description was incorrect, and his name was actually Siddharamu. And in the appeal preferred by him, his name has been correctly stated. He also states that as a consequence, even in this appeal, 5th respondent has been described as K. Siddharamu. The said explanation is accepted.
Lord, next explanation is, Lord, so far as, my lord, prayer is concerned, my lord, after disposal of the regular appeal, my lord, one more application has been filed, my lord, under Order 41 Rule 27. My lord, that application was separately disposed of by rejecting that application. My lord, we have challenged both, my lord. Therefore, my lord,
how can you do it?
No. After disposal of the RA, not we preferred an application. Application, my lord, page number 76, may kindly see.
Second appeal alli, how can you challenge it?
No. Regular appeal dispose ಆದ್ಮೇಲೆ ನಾವು ಒಂದು 41
ಅದಾದ್ಮೇಲೆ ಒಂದು
ಅಪ್ಲಿಕೇಶನ್ ಅದು ಸಪರೇಟ್ ಆಗಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಪೇಜ್ ನಂಬರ್ 76.
ಅದು ಅದನ್ನ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಹೆಂಗ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀರಾ?
ನಾವು
ರಿಟ್ ಹಾಕೋಬೇಕಲ್ವಾ? ರಿಟ್ ಹಾಕೋಬೇಕಲ್ವಾ? ಸೆಕೆಂಡ್ ಅಪೀಲ್ will only against a decree.
RA is already disposed of, my lord.
ಅದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿ ಅದನ್ನ ನಿಜ ಜೊತೆ ಕನೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕಲ್ವಾ? ನೀವು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ how can I set aside an order passed on an interlocutory application? Maybe it is disposed done afterwards.
Afterwards, my lord. Separate order has been passed.
ಹಿಂಗೆ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಹೆಂಗ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡ್ಲಿ ಅದನ್ನ?
Since, my lord, it is a continuation of suit, my lord, we have challenged the both orders, judgment and decree, and as well as the application. Order.
You have to challenge it separately. When was the RA allowed?
RA, my lord, on 30th August 2021. Page number 20. Page number 76, my lord, order passed on application 4 October 2021. That was the judgment was passed on August, my lord. This application was disposed of on October. We have produced, my lord, certain documents, my lord, and
But how can you challenge it in the second appeal?
My lord, order 41 rule, my lord, 27 producing some documents along with certain grounds.
Second appeal ಅಲ್ಲಿ 100 ಕೆಳಗಡೆ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ?
Since because, my lord, we have additional grounds we have raised, my lord, therefore we thought that, my lord, this is also continuation of suit proceedings, my lord. Therefore, our submission is, my lord, this is also amenable for
and also Bailan Maya.
You can only confine it to only the judgment and decree, not on the IA.
I will make my submission, my lord, of this matter next week, my lord. I will get
next week. Valuation slip ಹಾಕು ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. Why? Suit for? There's a plaint. Where is the paragraph regarding valuation? Where have we said in the plaint regarding valuation? ಏನೋ ಒಂದು ಕಾಪಿ ಹಾಕಿದ್ರೆ ಪೇಜ್ ನಂಬರ್ 113 ಟೈಪ್ ಕಾಪಿ. ಇದು ಯಾವ್ದು ಟೈಪ್ ಕಾಪಿ? Where have we said in the plaint that the suit is valued at rupees 1,000 and court fee rupees 25 is paid? Which paragraph? Now will you argue the trial court judgment is in Kannada? It is noticed that the suit is for injunction and a court fee rupees 25 is paid both to the trial court and the appellate court. Hence, production of an valuation slip is dispensed with for the time being. Post for admission. Court fee then ಆಗಿಲ್ವಂತೆ ನೋಡಿ. Division court fee rupees 850 to be made good. This is an yesterday's endorsement. 1 week to do the need. Supposed to be hearing in the first week of March. The second week of March. Number 49. First week of April.
Lord, appearing for 50, Lord.
First week of April.
Lord, may I request for an early date because an aged person, he is 90 years.
2006
and he
and
is
7
bedridden for 2013 appeals, Lord.
Correct, but 2006 and 7 were not yet disposed of.
True, Lord. I'm making a special request because the person is on deathbed. He's completely confined to the bed for last more than 2 years now. And his wish is he wants to hear some news about disposal of this matter.
Second week of March.
Second week of March. May I request for a date, Lord?
Date they will give afterwards.
I'll. Thank you. Obliged.
51 minutes. Lordship, 52 appeared for appellant in this matter.
51.
Last taken time to file affidavit or memo.
100, 51. 51.
Yes.
I before the respondent, appellant, I filed the objection to the IA.
What is the IA?
IA is for seeking a direction to release the amount in deposit regarding the compensation paid on the acquiring of the some of the property, which is one of the scheduled property of the plaintiff. Item number 10,
Item number 10, self-acquired property of my father.
You are for the plaintiff or defendant? Was decreed.
Appellate court reversed the finding on the ground that I could not have filed as a premature suit.
Appeal is allowed, my lord.
Matter is already admitted, my lord. It could be sent for a final hearing.
William Gopal sir cannot tell you. The daughter has filed a suit when the father is alive. That is not the contention. Now, this particular property, item number 10, my lords, is the self-acquired property of my father. My sale will get 26/1945. It is admittedly by some other self-acquired property. This property is included. Admittedly, I did not contest in the lower court. Now, this property is acquired for upper Kundamalla project. 56 lakhs is there. Now, there is only one share which the appellant is getting. As per the lower court, first trial court, this is for 1/4. He is entitled for one share.
Trial court dismissed your suit, isn't it?
No,
you are for?
I am for the respondent.
Respondent ಅಂದ್ರೆ plaintiff or defendant?
Yes, I am for the respondent. Defendant in trial court.
This is the third defendant.
ನಿಮ್ಮ ಹೆಸರೇನು? ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಹೆಸರು?
R3 CE Nanjundappa.
Mandara C. Nanjundappa. Suit was decreed. Plaintiff is entitled to 1/4 share.
1/4 share.
In respect of item number 1 to 10.
1 to 10.
Suit in respect of item number 11 to 13 is dismissed. Appeal was filed by?
Appeal is allowed.
And
the trial court judgment will be set aside.
The appeal was allowed only on the ground that suit is at premature. Father allowed, the daughter could not have filed the suit. That's the only ground on that. Now I think it's solved.
What is the direction that you are seeking for?
The amount which is to be dispersed. Now they have filed objection that is here. Cannot be dispersed. That's I am a retired professor. I don't have any other income. There is one share which is confined to her. Let that share be kept in the amount bank. In case she succeeds the appeal, she will take that share. In case she doesn't succeed, if I succeed, even that share will come.
Why should the entire money be even according to even if your suit is decreed, will be entitled only 1/4 share, isn't it?
My one share could be ordered to be deposited before the court, or the entire amount could be deposited in the court, and it matter is already admitted, my lord.
No, what will you get? What will you get if
I'm 1/4 share. The trial court has granted 1/4 share to me.
Apart from the appellate hearing, no other person is taking any right outside the property. Even her own father.
Lordship, I can see page number 61.
Entire amount I will not direct them to release.
Please, Manoj.
If she succeeds, what should happen?
Her share will be kept in the bank with her.
Then your prayer is for the entire amount, isn't it?
That's why I mentioned.
You specify with the memo as to what is the exact amount that she is entitled to, and that amount we kept in deposit. Remaining, I'll ask them to withdraw or to release.
That's the total amount is Manoj 56 lakhs.
ಅಲ್ಲ ಅದ್ರ ಜೊತೆ interest ಎಲ್ಲ ನಾಳೆ ತಕರಾರು ಆಗಬಾರ್ದು. You file a correct memo stating what is the amount that she is entitled to.
51,60,25 ರೂಪಾಯಿ ಅವರು ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದರ ಒಂದು ಶೇರ್ ಅವರು ತೆಗೆದಿದ್ದಾರೆ. ಇನ್ನುಳಿದ 3 ಶೇರ್
ಬೇರೆಯವರನ್ನೇ ಹೇಳ್ತಾರೆ.
ಅವ್ರು ಯಾರು ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. Even this Mahadevappa, he has recently exceeded a release in favor of the respondent here.
Reduce ಮಾಡಿದಾರಾ?
ಮೊನ್ನೆ ಆಗಿದೆ 21 ಆಗಿತ್ತು. ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಮಿಕ್ಕಿದವರು ನಂಜುಂಡಪ್ಪ. The third respondent.
I am for 20. They won't contest.
They won't alla. File an affidavit of them saying that they have no objection, just like Mahadevappa.
But Mahadevappa, as far as my knowledge goes, they have not exceeded any Makalat. And he recently executed a release in favor of the respondent here in respect of the other properties.
You are Bandera Nanjundappa, na?
Please, Manoj.
What about Kaleshappa and Sushilamma?
Sushilamma is the second wife of Mahadevappa. Second wife of Mahadevappa.
How can you take the entire money? Even according to what you got?
Sushilamma is nowhere concerned because she is the second wife of Mahadevappa. That she was made simply a party in the trial court.
Suit is for partition. If the suit is decreed, what is the effect?
They are entitled, but she is being served and not represented.
But still, you cannot take her money.
That's
We don't know whether she'll be entitled to a share or not.
That
is your contingent. That is your contingent which is decided here, isn't it? And how can you take that money? Appeal is admitted. A1 for direction shall be considered along with the main matter.
I give a proper calculation. I will get from the other.
After 2 weeks.
That was great. Retired professor.
Date could.
Retired professor.
28.
That's all. I filed a proper calculation. What is the amount?
Kumar.
In the both matters, my lords, it has become infructuous. I was to file a memo. Last date of hearing, it took time. I could not get it from the department with certain details, my lords. I seek 1 week time to file a memo. I will withdraw both matters. Both
for the respondents in this matter.
21st. Shyam Reddy.
My lord, I'm for the appellant, my lord. Actually, my lord, even at the very beginning, when filed the appeal before this honorable court, the second respondent, Srinivasappa, represented by his wife, Rajamma. I don't know where it went wrong, my lord. Actually, even amended plaint also we have filed. Rajamma is the second respondent.
Her husband was Rajman Resrena?
Srinivasappa.
What was his rank in the appeal?
He appeal only second respondent. Ali second appellant.
When did he die?
On 11/1/2016. ಇಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅವ್ರನ್ನ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ರು. ಬಟ್ ಲೇಟರ್ ಆನ್ ಇಟ್ ವಾಸ್ ಚೇಂಜ್ಡ್. ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಅಂತ. No, the correct position is Rajamma is the second respondent. That's all, my lord. All other parties remain the same. Even the notice is already served to all the parties.
11-1 11-10 ಕರೆಕ್ಟ್ ಆಗಿ ಅದು ನೋಡಿದ್ರ
11-1
ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರ?
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ, ಮೊದಲೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ.
ಎಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರ?
I will give the date also. Actually, how it was confused, my lord. I will come to the point. When we filed the appeal, we filed the correct proposition that Rajamma. But what happened?
ತೋರಿಸಿದ್ರಿ ನೀವು ಅಪೀಲ್ ಹಾಕಿದಾಗ
While
ವಕಾಲತ್
filing,
ಯಾರ್ದು ಹಾಕಿದ್ರಿ?
ವಕಾಲತ್ ನಮ್ದೆ ಸರ್. The death certificate is in page number 76.
The appeal was filed by whom? Sudharani and
Plaintiff in the original suit.
ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ ಅದ್ರ ಮೇಲೆ?
ನೋಟಿಸ್ ಎಲ್ರಿಗೂ ಸರ್ವ್ ಆಗಿದೆ. ಈಗ ಅಡ್ಮಿಷನ್ ಬರ್ಬೇಕು.
ಅಲ್ಲ, ಈ ರಾಜಮ್ಮಂಗೂ ಸರ್ವ್ ಆಗಿದ್ಯಾ?
ಸರ್ವ್ ಆಗಿದೆ.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರ ಅವ್ರಿಗೆ?
ಇಲ್ಲ, ಸರ್ವ್ಡ್ ಅಂತಿದೆ ಅಷ್ಟೇ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
It is stated that the second appellant before the appellate court, that is Srinivasappa, had passed away on 11/1/2016. After the appeal was disposed of, it is stated that by mistake, while filing the appeal, Srinivasappa was arrayed as the second respondent. It is also stated that Srinivasappa passed away leaving behind his only his wife, Srimati Rajamma, as the legal heir. And hence an application is filed to treat her as the sole legal heir. The application is allowed, and Rajamma, the second respondent herein, shall be treated as the sole legal heir of Srinivasappa. Post for admission.
ಅಡ್ಮಿಷನ್ ಬೇಕಾದ್ರೆ ಹೇಳ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ, ಬೇಕಾದ್ರೆ ಅಡ್ಮಿಷನ್ ಮಾಡೋಕೆ ಮಾಡಬಹುದು.
Next week.
Any date complete.
Next Monday.
Much obliged.
Since the right to sue
appearing for the appellants in this case, I'm appearing on behalf of D. Vinod Reddy.
1A bracket 1 to 5. The applications filed to bring them on record is allowed. Cost title to be amended. A number 2, 3 are accordingly disposed of. I1 for 19 shall be considered along with the main matter. Rohit Gowda. ಯಾವಾಗ? The appeal was dismissed for pending consideration of A4 2019 and consist of subject to 5 paper book shall file a sale within period of 6 weeks. January 21. Since paper books have been filed on 27th of January 2021, the order dated 27/6/2019 is recalled, and the office is directed to accept the paper books filed.
1 week to comply with the office objections. Next Monday. $57.58 post for admission along with the applications. Just 59 last. Post for admission along with the application. Monday, next Monday. Monday barli admission in. I can't do anything. I can't grant an interim or notice matter. Monday barli. A3 not post. 15 A3 is dismissed as not pressed.
Pertaining to Dharwad branch.
Serial 58 melons appearing for the appellant melons. 58 inch 58 melons.
Or isn't?
Plus for the appellant melons, serial number 58 melons.
Post for admission on Monday, next Monday.
Grateful melons.
Along with the IA.
Grateful melons.
Your Honor, serial number list number 3, serial number 8, Your Honor. List number 3, serial number 8, Your Honor.
Sir, ಅದು ಫೈನಲ್ ಇಯರ್ ಇನ್ನೂ ಇದು ಮಾಡಿಲ್ಲ ಸರ್.
Dharwad list.
Dharwad list ಬಂದಿದೆ.
Yes, Your Honor.
Serial number 1.
Eli Deshpande avare.
Yes, my lordship. Everything has been complied. The petitioner says that 3 installments of maintenance allowance has not been disbursed. ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ because of COVID, hostels were not functioning. ಹಿಂಗಾಗಿ ಅದನ್ನ ರಿಲೀಸ್ ಆಗಿಲ್ಲ. ಈಗಲೂ ಸಹಿತ through college, if they submit that they have stayed in hostel during that August 2020 to December 2020, that will be disbursed. As far as AICT is concerned, the order, everything is disbursed.
They stated that if the educational institution where the petitioners were staying were to submit a statement stating that the petitioners were residing in the hostel for the period August 2020 to December 2020, the maintenance charges will be disbursed. So the said statement of Sri Deshpande is recorded. The educational institution is directed to furnish a statement as to whether the petitioners were staying in the hostel during the period August 2020 to December 2020 within a period of 2 weeks.
That institution, East West College, is not party to this proceedings.
Like order ತಗೊಂಡು ಕೊಡ್ಲಿ ಬಿಡಿ ಅವಾಗ they'll give a statement.
ಸರಿ ಸರ್.
Madam, serial number 2.
Lord, in this, your lordships have directed me to serve the copy of the IAs filed for bringing LRs of number 3 on FB Patil, but unfortunately he has refused.
Patil re.
Therefore, your lordship.
My lords, I appear on behalf of the FP Patil, my lords.
Yes.
Lords, the party has taken the files, my lords. Kindly issue notice to the parties, my lords.
ಏನ್ ಮೇಡಮ್ ಇದು?
Your lordships had heard and dismissed our writ petition. Writ appeal was filed, and in that respond number 3's LRs were made as parties. Therefore, the division bench directed to file the application where the abatement took place. Therefore, review petition is filed to bring the LRs of this is respond number 3 on record.
Patil re.
Please, my lords.
If you take notice, I'll simply allow the application. That is all. Very cost it has to be amended.
No, my lords, after disposing of the petition, they have taken the entire file, my lords. Now we don't have right.
Issue notice on. ಎಲ್ಲಿದೆ ಮೇಡಮ್ IA?
IAs were filed on 28/1/2021.
issue notice of the review petition on ಎಲ್ಲರಿಗೂ ಕಾಪಿ ಹಾಕ್ತಿದ್ರ ನೀವು?
ಎಲ್ಲರೂ ಕಾಪಿ ಎಲ್ಲರೂ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 is ಎಲ್ಲರೂ.
That is ಶಿವಬಾನ.
Yes. ಶಿವಮ್ಮ.
ಬೇರೆಯವರು?
ಬೇರೆಯವ್ರಿಗೇನು ನೋಟಿಸ್ ಆಗಿಲ್ಲ. ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಆಗಬೇಕಾಗಿತ್ತು ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ಪ್ರಿಲಿಮಿನರಿ ಅಬ್ಜೆಕ್ಷನ್.
Issue notice to whom do I issue notice now?
Now your lordship is required to issue notice to the LRs of deceased Shivava.
ಯಾರು ಅವರು? ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ ಯಾರು ಅಂತ. You arrayed Shivava only as by respondent number 3. If Shivava is dead, what is the point in once again issuing notice to Shivava? You mute ಮಾಡ್ಕೊಂಡ್ರಿ ಮೇಡಮ್. If Shivava is dead, what is the point of issuing notice to Shivava once again?
No, LR application was filed to bring the LRs of deceased Shivava.
ಎಲ್ಲಿ?
ಇಲ್ಲಿ ನಾವು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅಲ್ಲಿ.
ಅಲ್ಲ ಇಲ್ಲೂ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಬೇಕಲ್ವಾ ನೀವು?
ಇಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ನಾವು WP ನಲ್ಲಿ ಹಾಕೊಂಡಿದೀವಿ.
WP ಡಿಸ್ಪೋಸ್ ಆಗೋಯ್ತಲ್ವಾ?
WP ಡಿಸ್ಪೋಸ್ ಆಯ್ತು. ಅದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ವಿ. ಅದರಲ್ಲಿ IAS ಅಲವಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿಬಿಟ್ಟು ದಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಡೈರೆಕ್ಟೆಡ್ ಅಸ್ ಟು ಮೂವ್ ದಿಸ್ ಕೋರ್ಟ್ ಬೈ ಫೈಲಿಂಗ್ ಅ ರಿವ್ಯೂ.
ಆಯ್ತು. If you make an application in this review petition, you should notice on that.
Very well, my lord. Next week I will file applications.
Next week.
But in this case, I appear on behalf of Mr. Pankar.
Yes.
What happened is, certain proceedings under SURFACE Act were initiated. But the advocate for the petitioner appeared before your lordships and made a statement saying that he will clear off the dues in 2 months. That your lordships will find in para 3. Para 3, page 3. Learned counsel for the petitioner seeks 2 months time to pay the entire balance amount. It is made clear that if the entire balance is not cleared within a period of 2 months, the bank will be entitled to confirm the auction share. Now, by mistake, annexure C, is produced, but that was a request for considering the application for one-time settlement scheme. But even
I disposed it off on the basis of the statement made by him.
Correct. I fully understand that. I also understand the limitations. Now, the point for your lordship's consideration is 188 lakhs was taken as loan in the year 2017, and so far 198 lakhs, about 10 lakhs extra is already deposited with the bank. Now still they are claiming 133 lakhs, but within a span of 4 years. So if our application is considered for one-time settlement scheme, but even now we are ready. But it is because of the mistake made by the advocate for the petitioner, stating that our application for one-time settlement also must be taken into consideration. In fact, the bank itself filed objection stating that
they have notice on Mr. Iramat. Let us see. Please. The Mallikarjun Swamy B. Iramat is ready to take notice for.
But in fact, I'm sorry. But we have the copy on Mr.
Copy has been served the other day.
OTS madakagalva.
No, last occasion my lord can recollect. This property is subject matter of 3 separate loans. There are 3 accounts, my lord. This is also a subject matter of a mortgage of other loans. So when this was brought to the notice of your lordships, my lord, sir, even if this amount is cleared, this property can be again proceeded with for the other loans. Your lordships can recollect that. I filed a detailed statement of objection.
He's saying that his request for OTS
let them consider and reject. Ultimately, if they feel that it is not acceptable, let our application be considered. That's all.
Even if for consideration, for the total outstanding, the 25% he has to then all. No, along with the application, is required to submit, make a 25% deposit of the amount which is outstanding.
85 lakhs.
Order itself will. That is with respect of one account. There are 2 other accounts. He, my lord, so what he does is,
This was the case in which they withdrew the writ petition, Tane. This was the case in which they withdrew another writ petition.
ಇನ್ನೊಂದು withdraw ಮಾಡಿದ್ರು. Yes, my lord.
The other one, and you deposit
They withdraw
25%.
ಮಾಡಿದ್ದೇವೆ ನೋಡಿ 85 lakhs ನೋಡಿ para 2 itself not would clearly indicate para 2 75 lakhs not during the pendency of the writ petition para 2 on 29/11/21 stay of the confirmation of the auction till date hearing they was granted since the petitioner had tendered demander of 10 lakhs and had furnished FD 75 lakhs. Today learned counsel for has furnished one more demand draft that is 10 lakhs. So not totally.
So Mallikarjun Swami,
real injustice, bro. That's all. Ultimately, I leave it to lordships, bro.
ಏನು ಇಲ್ಲ. It was specifically made. This submission was made. They enjoyed this 2 months time, my lord. Now, by way of a review petition, my lord, again they want to just similar, sir, postpone the my lord's confirmation of auction.
Let them consider and discuss of first.
No, I will not do anything. I will only say that if you are willing to consider his OTS proposal, notwithstanding this order, you are at liberty to do so.
ಅಲ್ಲ ಇದರಲ್ಲಿ my lord, the representation, my lords, kindly see and see is to extend the financial assistance by sanctioning additional loans ಅಂತ ಇದೆ.
Or allows to close all or above stated loan accounts under OTS scheme, giving due consideration. Consider that and pass some order. That is all.
That's all. Otherwise, not injustice would be caused not to the petitioner.
Can you get instructions as to whether you can consider under the OTS?
Try to get. By Friday, am I audible?
Yes, next Monday.
Please.
Next Monday.
Not before 28th, my lord, may I request, my lord, before 20th. 28th, my lord, that is, not your lordship, kindly have it on the 18th, my lord.
18th.
Please.
Oblige, my lord.
Oblige.
Please, my lord. Last time, my lord, they have requested this whole court that they will get some documents, etc. And submitted that they have not any documents.
Who appears for the
respondent? Your lordship, the only question before this honorable court was whether notice was issued to the petitioners under section 11 of the Slum Act, your lordship. So for that, our contention was the notices were issued and those documents were with the divisional commissioner who was appointed then for declaring this as slum, your lordship. So those documents were sought by this honorable court and those documents were before the honorable Bangalore bench of this honorable court. So the documents were to be procured by the state, your lordship. If those documents are procured, the only thing to see was if the notices were issued or not. If the notices were issued, then the writ petition fails, your lordship. And if the notices were not issued, then this honorable court may pass orders on merits, your lordship.
No, you have not acquired the property. Despite acquisition of the property, you have built up a structure there.
Please,
isn't it?
Please, your lordship.
What is there to show that you acquired the property?
Now, if the notices.
Who appears for the state here?
Acquisition proceedings are pending.
Who appears for the state?
I'll have to verify, your lordship.
Serial number 4. Then records ತಂದು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. Monday, next Monday. Next Monday.
Obliged, Your Lordship.
Lords, I appear for the respondent number 2 in this matter, my lords. Lords, my lords may kindly have this matter tomorrow, my lords. My senior colleague is having some personal inconvenience arguing the matter today.
Where's Girish?
I appear for the petition.
Naಳೆ ಬೇಕಂತೆ.
Apart from that, Lord, if I may make a submission, on 21st of January, my lords are pleased to pass an order directing the respondent number 1, my lord, bank to produce the documents. The matter is at that stage, my lord.
Who appears for R1? Patil.
Max, I am appeared for the R1.
Record in Kodalva?
Records are all already with the concerned officer, which were produced last occasion.
The DR record.
The DR is in all papers.
No. Produce the entire records available with the bank in relation to the sanction of the loan, which is the subject matter of these writ petitions.
As per instructions, they have submitted all the records to the DR office.
DR ಹತ್ರ ಇರೋದು ಅಲ್ಲಿರೋ ಡಿಸ್ಪ್ಯೂಟ್ ಲೋನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲಿದೆ ನಿಮ್ಮ ಫೈಲ್ ನಿಮ್ಮ ಫೈಲ್ ಯಾಕೆ ಅವ್ರು ಕೊಡ್ತೀರಾ
ಅವರಲ್ಲೇ ಲೋನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ DR ಆಫೀಸ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನಮ್ಮ ಕ್ಲೈಂಟ್
ಅಫಿಡವಿಟ್ ಹಾಕ್ತೀರಾ ಹಂಗಾರೆ ಐ ಹೋಲ್ಡ್ ಇಟ್ ಅಗೇನ್ಸ್ಟ್ ಯು ದಟ್ ಇಸ್ ಆಲ್
ಅಲ್ಲ ಹಂಗ proper instructions and
it will be not with the recovery officer. Recovery proceedings have been initiated. The file will be with the recovery officer.
Wherever they should say. If they are not saying where it is their problem. I will hold that it did not produce it. That is all.
No, it may go against us, my lord. Therefore, my lord, I am making submission. Let them take.
It will be taken next week. I will keep the part.
Next Monday, you file an affidavit saying that you don't have the records, or you will not produce the records. Whatever you file an affidavit.
Please.
Next Monday.
Okay.
I appear for the petitioner, my lords, in this.
Yes.
My lords, this is, my lords, regarding dealership in retail outlet of petrol and diesel stations, my lords, where the petitioner as well as respondent number 5, both were applicants, my lords.
They are marks card.
Yes, my lords. Lordship had directed the respondents to produce the records, my lord. Last occasion.
Please, my lord. In this case, my lord, the honorable court had directed Mr. Ramesh Misale to produce the file, my lord, the records, my lord.
Yes.
He represented in the first case, my lord. In the second case, only I represent, my lord. The first case, the honorable court had passed an order.
Where is he?
My lord, I couldn't see him, my lord.
Tell him I'll take it up on Monday by now. Next Monday, let him keep the records ready.
Yes, I will intimate him, my lord.
Please, my lord.
Jagdish Patel.
I appear for petitioner, my lord.
My lord, in this I appear for respondent number 2, my lord. My lord, the government needs to approve the amount, my lord. So I need a week's time, my lord.
Next Monday.
I need my lord from the please. Oblige.
Sangram Kulkarni.
My lord, I appear for respondent number 1 name, my lord.
ಏನಾಯ್ತು?
My lord, sir.
My lord,
appear for the petition in this case. My lords, the society has informed Vishwanath Hegde, my lords, regarding the proposal, my lords.
ಏನು ವಿಶ್ವನಾಥ್?
No. My lord, I am not at any instruction, my lord. My lord, they filed affidavit before this honorable court dated 22/12/2021, my lord. The affidavit does not disclose the what amount actual due to the respondent, my lord, it is not forthcoming, my lord.
This affidavit was heard in part, my lords. Thereafter, my lords are directed regarding the amount, my lords, what the quantum of the amount to be given to the respondent. In fact, my lords, the secretary had called him, my lords. There was talks and gone, my lords. Talks were there, my lords. Now, since, my lords, we had given a proposal, my lord, the society, the secretary, my lords, it was forwarded to him, my lords.
My lord, I have not received any proposal, my lord. This is my submission, my lord. Even a single proposal I have not received, my lord, from the society, my lord.
ವಿಚಾರಿಸ್ತೀರಾ?
My lords, then, my lords, I'll give his number.
Monday,
please.
Next month.
My lords, next Monday, personal inconvenience. I'm sorry, my lords. Any next date on next Monday, my lords. Senior.
Tuesday.
Aye. Obliged.
What is the basis of the claim?
There are numbers for the remaining acre. I have applied for conversion. Without completing on those articles, we can dispute over the for divorces is saying that after the acquisition, what is the extent to remain between us?
Where is that finding? What is A and B? ಎರಡು schedule ಹಾಕಿದ್ರಾ?
The entire property plus 60 the registered schedule is
Second defendant.
Here, is not the registered for that is entire estate. I purchased a site which is on in the neighborhood.
60/30 ತಗೊಂಡ್ರಾ? Under the sale it dated? 33. Out of which how much was acquired?
Acquired portion is because of road is acquired. Remaining that is the remaining portion. Other than that, municipality has extended because
40 plus 25/2 now.
that is shown in this schedule. This is the property which is in my possession now.
East by ಏನಿತ್ತು ಮುಂಚೆ? East by ಏನಿತ್ತು ಮುಂಚೆ? Space left for conservancy. Where is the finding of the appellate court?
The price schedule shows two glacial property aside.
What is exhibit P5 to P10?
There are conversion orders and the exchange deed executed by the municipality might ever remain, there is a remaining portion of stone. And the Khata extraction and all those things. But exhibit people is
local newspapers.
I have also produced the layout plan also. The time of purchasing the property, there was a layout already been found.
Call for records. Issue notice. Defendant ಏನಿತ್ತು contention. ಏನ್ ಖಾಲಿ ಸೈಟ್ ಇದು? Both the parties to maintain status quo.
My lord, appearing for the appellate in this case, my lords. My lords, I have filed a memo in respect of the, as agreed, my lords, on the last occasion.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, my lords. I have sent it through email, my lords.
Prabhakar.
I represent the respondent, my lord. In this case, my lord, on the last occasion, the court had informed that the appeal will be dismissed. The counsel for the respondent has filed a memo stating that the defendant is in lawful possession of the property within the boundaries and compounded with the property sold by the plaintiff, my lord. The plaintiff has acquired 4 acres of land from Ramaya, his vendor, and the said property is sold to the defendant, my lord. The memo for which is filed by the plaintiff is contrary to the suggestion made by the honorable court, my lord. Memo should be simple, my lord, and it should only speak about withdrawing of the appeal, containing that the defendant possession and for the rest of the land, and the plaintiff is not clear.
ನಾನು ಹೇಳಿದ್ದು ನೀವು ಸುಮ್ಮನೆ withdraw ಮಾಡಿ appeal. I will say.
My lord, I'm simply withdrawing it, my lord, by saying the reasons why I'm taking the risk, my lord. I'm stating the judgment says like this.
The word
here, the same thing.
The word here used is in terms of this memo.
Please, my lord. That your lords may kindly that last sentence. Your lords may that may kindly be this, my lord.
And consider the appellant has filed a memo in which it is stated that the appeal may be dismissed in terms of the memo. However, and counsel submits that it may be simply permitted to withdraw the appeal. Accordingly, recording the said submission, the second appeal is dismissed as withdrawn. It is however open for the appellant to initiate proceedings in respect of the land which he claims to own apart from the land that he has sold to the respondent herein under the sale deed dated. ಯಾವ ಸೇಲ್ ಡೇಟ್ ಅವ್ರದ್ದು?
My lord, the
sale deed dated 35/9/7.
Sale deed
is an extent of 5 acres. And which is situated
30/11/1989.
The Budagiri Road and bounded on the east by exhibit P34 alva?
Exhibit P59, my lords.
Madam, the sale date?
P34 is the original one, my lord. Subsequently, P59. P34 is also right, but subsequent sale, P34 is how I have purchased. I have sold as per P59.
P59.
Oh, P59. That's what actually I have mentioned, my lord, clearly in the memo itself, my lords.
Where is the sale deed that
59.
Madam?
Sir.
Nim property tane abutting the Budgere Road.
Howdu. May take a lot to para.
Which is sold by the appellant in favor of the respondent under the sale deed dated 30/11/89, exhibit P59, and which is situated abutting Budgere Road.
My lord, I have just extracted defendant's contention 3, para 3, my lord. Please, my lord. The suit itself be permitted to be withdrawn, my lord.
Yes.
Suit itself, my lord.
Consequently, the suit shall also stand dismissed as withdrawn.
Please. And the right of the my lord to plaintiff, my lord, to claim his properties, my lord, as mentioned, 5 acres. Uttara kilo, Dakshina kilo, the prashna irodu.
I have said that apart from the property that you have sold, which is abutting the Budgere Road, you are at liberty to initiate appropriate proceedings.
Please. And also, my lord, to get his lands podied, my lords, in accordance with law.
Whatever you want to do.
Please. Permitted to be withdrawn, my lords. Dismissal withdrawn, my lords, please. Please, great.
2006. What is the suit for? Come, let us see. ಹೇಳಿ ಸರ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ ನೋಡೋಣ ಆಮೇಲೆ ನೆಸೆಸಿಟಿ ಇದ್ರೆ second appeal is by the first defendant.
Yes, sir. There is a concurrent finding, my lord. The trial court has decreed
What is the property, suit property? Seven items. Relationship is in dispute. How are they related? They're all others. And children are meditation. Yes.
Children of meditation.
Who is D4?
D4 is the son of the landlord.
Son of?
So,
tenant property.
Tenant number 1 was the tenant under the father of
D1.
Yes, D1 was the tenant under the father of the defendant. The father of the plaintiff and defendant number 1 to 3 was agent of the father of the defendant number 4, and he used to collect the rent.
Plaintiff?
Plaintiff and defendant number 1 to 3 father.
Venkateshaya.
That is Venkateshaya. Was the agent of the father of the defendant number 4, that is landlord. He used to collect the rent.
From whom?
From all the tenants, including the defendant number 1.
Swanta Magnatrane. That is your cut.
He makes a statement before the land tribunal that these are all the persons who are the tenants. And they used to pay the rent.
You are the.
I am the defendant number one, and I was the tenant.
So you are saying that you are paying rents to your own father.
I was paying the rent to my landlord, that is the father of defendant number one, and my father used to collect it as an agent.
So what? Now ultimately, the suit was granted to you. The land was granted to you.
The land was granted to me.
Because your case is separate property.
It is a self-property.
Exclusive tenancy.
There is no evidence to suggest that it is a joint family property. There is no evidence to suggest that the application was filed on behalf of the joint family. On the contrary, there is sufficient evidence to show that it is my self-acquired property. The word fraud has been used in this case, saying that fraudulently I filed an application. If that is the case, there is no evidence to support that.
Both the courts held that it was the family was collecting the land as a tenant. Why do you say it is wrong?
The reason is that the land tribunal order itself says that the statement has been made by beneficiary like that these are all the persons are tenants. And that is the finding, my lord, and that is the order. The entire finding of this particular.
So your own father has said that all of you are tenants.
Yes, all of us means the person who had made the application, I alone made the application.
That makes no difference. Where is the statement?
Statement is not there, my lord, there is an order. The order, my lord, is find that page number 90. My lord will find my name at serial number 4, my lord. That is different number 1, my lord. Page number 19 is the land tribunal order, my lord.
Serial number 4.
Yes, serial number 4, my lord.
Kundura.
My lord will find the name of A.V. Chandrasekhara, my lord. That is the different number 4, my lord.
Tande Shanbogra.
Yes, my father was a Shanbogra. My other brothers, they pursued their education. One was in Pune, another was in Bangalore, my lord. I was alone at my place, and I was doing the agriculture.
So all that this proves is the land was tenanted.
Yes, sir, it was a tenanted land. There is no dispute.
What is there to show that you are residing separately and
There are no other evidence, my lord.
any other properties that the family own?
Yes, there are two properties owned by the family. Those two properties are not included in the suit for the partition. And for that reason, I have filed an application for amendment of my return statement.
No. You didn't file it there. What was your defense in the?
My defense, my lord, at page number 9 is my return statement. Before that, may I take my lord the page number 10 to be easy to explain my defense. I will not read, my lord, I will just draw.
The plaint only says that all for the lands were tenanted and was being cultivated by all the members of the family.
They say that fraud has been taken.
It's called a fraud, but ultimately they said it is joint family property because
And among the children, that he would make an application on behalf of everyone. Those are the plea which they have been raised. Those plea, my submission is that should have been proved. And I will read my lord the written statement, but I will take my lord to the written statement. I will just draw my lord's attention to few sentences. I will not read the plea. My lord, page number 1, my lord, is the plea.
you were also a village accountant.
I was a village accountant and I was also a lorry agent.
And I used to do the agriculture. Well, after the marriage of my first daughter, my lord, I filed form number 7. Can you appreciate the fact? It was not that at a young age I filed the application. After the marriage of my first daughter, I filed the application for form.
Have you produced a form number 7 here? Where is it?
I request my lord to kindly take page number 49, my lord. The executive one, my lord. So, lord, start page number
49.
And in fact, one of the tenanted property which was
Road next is 26 acres.
53 acres, my lord. Roughly it comes to 55 acres.
According to your unit, 5 acres of land.
Page number 50, my lords can see.
This number?
Page number 50, my lord. Page number 50. If there was any other family property which was under cultivation, it would have been explained. So there are 2 other properties. So the grand family property is not explained.
So what follows if you not inform the land tribunal that you own other properties?
That is not the relation. Because there is a separation, I was not with the land after
What is your plea? Let us see your plea
yes.
first.
Before that, my lord permits sanitary. 2 sentences.
Now I will proceed on the assumption that you were separate and you were reciting separately. Let us assume that for a minute. What was your defense at you? Yes.
Specific assertion is that it is not the father who was looking after the affairs of the property or the managing the things in the property or lease from Venkatramaya, but is the first dependent who took the property on lease from one owner. That was the assertion. And I have denied entire case of the thing.
But your statement that your father was not the agent is denied by his own conduct.
I have not denied it.
No, when paragraph 2 is false to say that Venkateshaya was an agent of Venkatramaya. So if you are saying that he was not the agent, then your father himself came before the land tribunal and said in the presence of the landlord that he was the agent.
My submission is that is the plea what I have taken, my lord. But the principal plea is that, my lord, what you have taken is that it is not the father who was cultivating the property. You are not a tenant. It is false to say that Venkateshaya, who it was very delicate, so he did not give any declaration under section 48 of the land. But he was not cultivating the land as well. So he did not give any declaration since the property was cultivating the land. He gave a declaration under section 48 of the land. It is false to say that at the time of giving disposition of the property, Venkateshaya consulted the landlord and himself, and they enlisted the property.
Where is the plea that you set up that you got yourself separated from the family? Yes.
He can move the authorities to register the occupancy right before the land and the land was right. It is his self-acquired property and the plaintiff and defendants have no right over this. And they are not entitled to any share in the property. The first defendant alone was out of his own money has paid the money to the government. At various instances, plaintiff defendant and two people are not participating to pay the premium. The person of the order was by Tata has been changed the name of the person and he has been in possession of the property.
Where have you said that you got yourself separated? Lee, there is nothing of a prior partition.
Question of prior partition does not arise.
No, if you are claiming that you were separate, then you should have said so. That I have no connection with my family. I was doing this separately.
It is my self-appointment.
No, yeah, that you have said. But in order to prove that, you will have to show that you went out separately and you are not, because you are saying it is your tenant for the past 10 years. Correct?
Yes.
So how old were you when you took the property on lease? What was your source of income to cultivate the land? Nothing is there on record.
My submission is that. It is my assertion is that I am the tenant. It is my self-appointment. I have been stating my claim under the land tribunal order. That particular land tribunal order specifically mentions only. And I have been saying that I have paid this particular order. Now, jointness of the property, existence of the joint family, the primary owner lies on the building.
If it is denied.
I have denied that particular fact.
Where?
I have denied it entirely.
No. That's why I said you never said anywhere that you got yourself separated and there is no joint family in existence.
Even if I am in a joint family, I put it like this, my son is that there is a denial. Even if there is a joint family, if it is my self-acquired and if my own property, then we cannot presume that it is a joint family. Even if I am in a joint family. So that is my submission. And accordingly, my lord, this was my submission is that it was not, and question of law is also whether the primary onus is on me or onus is on the plaintiff. More so when there is a land tribunal order, and more so my name alone is shown, more so when it is not an application form filed on behalf of the state. So in such circumstances, my lord, the onus is on the plaintiff.
So according to you, you made an application while you were joined with the family?
That is not my case. I was.
Because you don't deny the fact that there was a separation.
Question of separation does not arise at all.
And you don't set up the plea that the other family properties which ought to have been joined in this suit. That is also not your plea.
That was not my plea.
Then
it is the plaintiff who is supposed to bring all the properties of the partition joint family property. He cannot bring only tenanted property for the partition.
you should have said so. You should have said.
Yeah, I should have said.
Then, that means there is no family property apart from this property.
These are the two other properties are the joint family. It is for the plaintiff to bring all the properties for the partition. It is not for me alone to bring it. It is the person who has knocked the door of the court seeking for the partition, saying that these are all the joint family properties. He cannot be selective only to the tenanted property or my self-acquired property. When he is selectively seeking partition with respect to certain property which is my self-acquired property, it is very clear that these are not the joint family. For that reason only, my lord, I want to read the claim. Then it would be easier, my lord, to understand the.
No, I understood. ಅವ್ರು ಶಾನ್ಭೋಗ್ರಾಗಿದ್ರು ಅವರೇ ಅರ್ಜಿ ಹಾಕ್ರೆ ಚೆನ್ನಾಗಿ ಕಾಣಿಸಲ್ಲ ಅಂತ ಮೊದ್ಲು ಮಗನ ಕೈಲಿ ಹಾಕ್ಸಿದ್ರು.
Let us presume that. What is the evidence to that effect? To show that particular aspect. Now, that was the case of the plaintiff. Then in that event, my lord, section 91, 92 of the Indian Evidence Act would come into play. And in that event, they want to produce the evidence to contradict to the exhibit given. There is the evidence to that.
I am telling you repeatedly, since you do not dispute that you are residing jointly, there will be a presumption that all of you were joint.
My submission,
all of you are living joint. First.
No, from 1964 onwards, we have been.
Where you should have pleaded that.
That evidence is available on record, my lord. Oral evidence is available on record, and it is a partition suit. I am saying that it is not a joint family property. And let us try to understand with the immediate fact what they have pleaded in the plain method.
I find it difficult to believe that one person in the family was capable of looking of 26 acres of land all by himself. Or else you could have also you.
They have to say whether they were in that particular village, or whether there was a joint cultivation, joint labor was there. How many years they cultivated? Why my name alone appeared in the revenue records from the 1964? All the things have to be answered by them. Let me permit me to read the plaint, my lord, then it would be easy.
I read the plaint. Both them. I read the plaint. I read it once again. Please read.
My lord, para number 2, my lord, the death of the father of the plaintiff and defendant 1 to 3 has been mentioned, my lord. That is 1919. Then, my lord, the array of the party has been mentioned. Then, my lord, we was serving as a Shanvoga and also looking after all the lands.
When was the order of the land tribunal?
1979. 21 June 1979.
120?
21st June 1979.
Yes.
Then, my lord, Venkateshaya, the father of the plaintiff and defendant, was serving as a Shanvoga and also looking after all the lands of
Yes.
late Venkateshaya was serving as an accountant and agent under the father of the and he received the Potige as Shanvoga. Potige he was receiving rupees 300 per year. Rupees 300 rupees was the Potige per year. Late Venkateshaya was cultivating the land as a SC and he had to give the declaration under section 48A of the land records for the conferment of occupancy right to the land. It was very delicate and unwise for Venkateshaya being Shanvoga and also as agent under the late state Venkatramaya to give an application in the form of the civil, taking occupancy right with respect of the land which it is. Though Venkateshaya was the father and looking after the properties, he enlisted the management of the property and to avoid the legal burdens. Then at the time of giving the application, in form number 7 for the occupancy right under section 48A, he consulted his landlord Venkatramaya and his also son as to what is to be done regarding the file of it. Then all of the sons unanimously decided on behalf of the entire family and legal necessity of Venkateshaya and did not fit to ask the first defendant to file the application before the land tribunal for registration of occupancy. Considering the worldly knowledge and being the
Village.
the first defendant has got some knowledge and idea about the transaction in the land and also he is easily availability in the village. I was alone in the village. That is only one more factor. On the advice of late Venkateshaya and brothers including the plaintiff, the first defendant gave an application before the land tribunal dated 31st December 1960. Even at the time of filing the application, believing the bona fides of the first defendant, neither Venkateshaya nor the plaintiff or any of his brothers were not suspected what is written in the form number 7 and how it is filled up. Now my submission is that, my lord, they are expressing their doubt about the form number 7. That is their plea and how it has been filled. Now there is a declaration by the father of the plaintiff and defendant number 1 to 3. Now if this is the setup, if this is the plea which they have raised, that particular plea is contrary to the form number 7 as well as the statement made by the father. Father, if at all they say that was managing the affairs of the property, he was Karta of the family. If that is the so, whether this particular plea is established, proved is the question in the light of the land tribunal. My submission is that, my lord, it remained as a plea. It has not been proved. Only on the basis of assumption the court has come to a conclusion. No, it might have been a joint family property. It must have been, father must have been instructed. Whether that can be, my submission is that that particular findings given by the court is contrary to the section 91, 92 of the Indian Laws. So, my lord, it continues like this. The case has been registered before the land tribunal in when the case was ripe for consideration, the landlord was dead. His son forthwith is the defendant represented the case. Ultimately, the case was posted for appearance of the parties on 21st June 1970. On that day, the first defendant number 1 represented the case on behalf of the family. And occupancy rights have been transferred in the name of the prosecutor. Even at the time of plaintiff and defendant number 2 and 3 did not suspect the modus operandi of the first defendant. Believing that the first defendant would not deceive and resent the fact that he alone is the claiming the occupancy. Even the son of Venkatramaya, the fourth defendant, did not suspect the bona fides of the first defendant, and he gave a consent for occupancy being granted in favor of the first defendant, thinking it is on behalf of all the sons of late Venkatesh. Even Venkateshaya has also made the statement that the same may be granted in the name of the first defendant, and this is an admission. Now, if he is the agent, if he was the person interested, he should not have made the statement. Now he has made that particular statement. Now I say that this particular statement, not on behalf of the entire family, it is on behalf of one particular person. And that particular statement.
Your claim was that your father was not the agent, correct?
My case is that my lord, he was looking after all the affairs of the.
You have denied that in the written statement.
Yes, sir, I have denied that.
But your landlord came before the court and said that yes, they are tenants. Along with the landlord, your father also came to the court and he said that yes, I was the agent collecting the rents and all of them are tenants. So therefore you should have, by your own conduct, by your landlord's conduct, been paying the rents to your father. Is that your plea, that you are paying rents to the father? Period, that you are paying rents to your father. First show me the plea, because in the plea you deny that your father was the agent. If you deny your father was the agent and your landlord says that he was the agent, whom were you paying the rents to?
It is the land tribunal order, my lord. It's not the plea of the plaintiff, or it is not the plea of the defendant. What is the plea? Because it has to.
So your main plank of the argument is land tribunal order is in your favor, therefore it has to be considered as your separate property. That is all, correct?
That is, and in the light of section 92, my lord, this particular grant certificate overrides all other plea as well as other evidence. That is not clear. And once this particular land tribunal order is there, if they are setting up a different plea, that particular different plea, contrary to the statement made in the occupancy certificate or the order of the land tribunal, they have to properly read the evidence, they have to place the evidence, and they have to prove it.
Did you examine your landlord?
The landlord was the defendant of the four of the party, he remained our expert.
So there's no evidence support from your landlord saying that you were his tenant.
Because there is the order itself speaks about it. That order itself speaks that I was the tenant under the defendant of the.
What is the evidence that you want to read?
I request one more paragraph, I one particular sentence, paragraph number 3. From the bottom, my lord, around 8th line, my lord, it starts like this. These facts demonstrate.
Yes.
These facts demonstrate that first defendant must have made fraud on his brothers by denying the very rights of brothers for the land for which the land. Now I request my lords to kindly take the cross-examination
of
PW1.
Yes.
I request it starts from page number 12.
Which portion do you want to read?
I will read from examination sheet. My lord, relevant portion, I will not read by time. Page number 12. Page number 13. First line, my lord, ನಮ್ಮ ತಂದೆ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಗೆ ಅರ್ಜಿ ಮಾಡಿಲ್ಲ. ಅದಕ್ಕೆ ಬದಲಾಗಿ ಮನೆಗೆ ಪ್ರತಿಯಾಗಿ ಅರ್ಜಿಯನ್ನು ಹಾಕಬೇಕು ಎಂದು ಸೂಚಿಸಿತು. ಮನೆಯಲ್ಲಿ ನಮ್ಮ ಅಣ್ಣನೇ ದೊಡ್ಡವನಾಗಿದ್ದರಿಂದ ಹಾಕಬೇಕು ಅಂತ ಹೇಳಿ. Then my lord, paragraph 3, my lord. Paragraph 3, line 4, my lord. ಎಲ್ಲ ಆಸ್ತಿಗಳನ್ನೆಲ್ಲ ಒಟ್ಟಿಗೆ ಅನುಭವಿಸುತ್ತಿದ್ದೆವು. This is the statement. It is a remained as a oral evidence only. All the RTC prior to filing of an application, my name alone is applied.
So in the RTC, according to all the family members' name will be written.
If the father was there, father name should have been mentioned.
So father's sons also names will be written.
Yes, if it is a joint cultivation, joint family, my lord, neither it should.
ನಾನಂತೂ ನೋಡಿಲ್ಲಪ್ಪ. ಎಲ್ಲ ಮನೇಲಿರೋ ಎಲ್ಲ ಗಂಡು ಮಕ್ಕಳ ಹೆಸರು ಬರೆದ್ರೆ ನಾನು ನೋಡಿಲ್ಲ.
one thing. If it is one other particular person name, my lord, it should be in the name. In that event, my lord, what is the inquiry the court has to do? Is that circumstances?
I accept the argument. Next.
My submission is that.
Oh, this is something new that you're telling me, that in the RTC, the names of all the brothers will have to be entered. Only then it can be presumed that it is joint and third. Salpa was a bit.
In the event, land tribunal not grants the occupancy right in favor of the joint family.
That is why at the initial stage itself, I asked you in the written statement, if you have taken up the plea that you got yourself separated from your family, you had absolutely no connection with them, and you were cultivating land all by yourself. I can understand, examine the plea. You very quietly keep quiet. You deny that your father was the agent of the landlord, whereas the landlord comes and says, yes, so and so Venkateshaya was the agent. On the basis of Venkateshaya's statement, you get the benefit. My question is, to whom were you paying the rents?
I was paying the rent to the landlord.
Who's the landlord?
Landlord was Venkateshaya.
How much did you pay? Have you said all that?
Yes, I was stating in my oral evidence. What he means, my lord, is a partition suit. I have to state that this is the self-acquired property. This is
Let us see your evidence.
Paragraph 4, second line. ಒಂದೇ ಪ್ರತಿಯವಾಗಿಯೂ ವಿಲೇಜ್ ಅಕೌಂಟೆಂಟ್ ಆಗಿತ್ತು ಮತ್ತು ಬಸ್ಸಿನ ಏಜೆಂಟ್ ಸಹ ಆಗಿದ್ದರು. I had a separate income, I was able to pay the rent as well as the premium.
And you are cultivating the land apart from being a village accountant, a business bus agent, 26 acres, 3 professions.
Other plaintiffs at defendant number 2 and 3, they used to do their own business in their own places. I was alone the person who was in the village.
Right.
It is not unknown fact. It is a person can manage the agricultural land as well as he can do the business manner, and I used to do that.
Others can't do.
Others can, because they one particular person was in Pune, the other person was in Bangalore. They were not in the Telecast village. For that reason.
Right.
I request my lordship, page number 14.
Page number 14. Yes.
ಭೂನ್ಯಾಯ ಮಂಡಳಿಗೆ ಸಲ್ಲಿಸಿದ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಅರ್ಜಿಯನ್ನು ನಾನು ನೋಡುತ್ತೇನೆ. ಸದರಿ ಅರ್ಜಿಗೆ ಯಾರು ಸಹಿ ಹಾಕಿದ್ದಾರೆ ಅಂದರೆ ನಮ್ಮ ಕುಟುಂಬದ ಎಲ್ಲ ಪರವಾಗಿ ಗುಂಡೂರಾವ್ ಸಹಿ ಹಾಕಿದ್ದಾರೆ. ಫಾರ್ಮ್ ನಂಬರ್ 7ರಲ್ಲಿ ಗುಂಡೂರಾವ್ ಅವರು ಕುಟುಂಬದ ಎಲ್ಲರ ಪರವಾಗಿ ಸಹಿ ಹಾಕಿದ್ದಾರೆ. ಫಾರ್ಮ್ ನಂಬರ್ 7ರಲ್ಲಿ ಕುಟುಂಬದ ಸದಸ್ಯರ ಸಂಖ್ಯೆ ಎಷ್ಟು ಸದರಿ ಅರ್ಜಿಯಲ್ಲಿ ಗುಂಡೂರಾವ್ ಅವರನ್ನು ಸಹೋದರರ ತಂದೆಯ ಹೆಸರುಗಳನ್ನು ಗುಂಡೂರಾವರಿಗೆ 5 ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳು. ಅಂದ್ರೆ ಅರ್ಜಿ ಕೊಟ್ಟ ಸಮಯದಲ್ಲಿ ಮೊದಲನೆಯವಳಾದ ಪದ್ಮಳ ಮದುವೆಯಾಗಿದೆ. 1974 by that time one of my daughter, that is the eldest daughter, was married. ಉಳಿದವರ ಮದುವೆಯಾಗಿರಲಿಲ್ಲ. ಫಾರ್ಮ್ ನಂಬರ್ 7ರ ಉಳಿದ ಕಟ್ಟಲು ಕೋರ್ಟ್ಗೆ ಮಂಡಳಿಯಲ್ಲಿ ಸಲ್ಲಿಸಿದ ಸ್ಥಿತಿ ಬಹಳ ಕಾಲವಾದ್ದರಿಂದ ನನಗೆ ತಿಳಿದಿಲ್ಲ. ಸದರಿ ಅರ್ಜಿ ತೀರ್ಮಾನವಾಗಿದ್ದ 1976 ಅಥವಾ 78ರಲ್ಲಿ ಭೂಮಾಲೀಕರಿಗೆ ಕೊಡಬೇಕಾದ ಹಣದ ಬಗ್ಗೆಯೂ ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. ಸುಮಾರು 300 ಇದೆ. ಸದರಿ ಹಣವನ್ನು ಶ್ರೀ ಗುಂಡೂರಾವ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನನ್ನ ತಂದೆಯವರು ನಮ್ಮ ಕುಟುಂಬದ ಆದಾಯ ಖರ್ಚಿನ stated is that my lord, amount was paid to him. ಫಾರ್ಮ್ ನಂಬರ್ 7 ಸಲ್ಲಿಸುವವರೆಗೆ ಆಸ್ತಿಯ ಪ್ರಮಾಣ ಪತ್ರಿಕೆ ಯಾರ ಹೆಸರಲ್ಲಿತ್ತು? ಆ ಸಮಯದಲ್ಲಿ ಪ್ರಮಾಣ ಪತ್ರಿಕೆಯಲ್ಲಿ 1ನೇ ಪ್ರತಿವಾದಿಯ ಹೆಸರು ಅಂತ ಹೇಳುತ್ತೇನೆ. ಅವಳ ಜಾಮ ನಿರ್ಣಾಯಕಾರಿಯಾಗಿ 1ನೇ ಪ್ರತಿವಾದಿ ತನ್ನ ಪ್ರಮಾಣೀಕರಣಗಳು ಸರಿಯಲ್ಲ ಅಂತ ತಕರಾರು ಮಾಡಿದ್ದರಿಂದ ಕುಟುಂಬದಲ್ಲಿದ್ದಾಗ ತಕರಾರು ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ 1ನೇ ಪ್ರತಿವಾದಿ ಕುಟುಂಬದ ಪರವಾಗಿ ನ್ಯಾಯಮಂಡಳಿಯಲ್ಲಿ ನನ್ನ ತಂದೆಯವರ ಹೇಳಿಕೆಯನ್ನು ದಾಖಲು ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ. ಅದು ನನ್ನ ಹತ್ತಿರ ಇದೆ, ಸದರಿ ಇದೆ. ಸದರಿ ಹೇಳಿಕೆಯಲ್ಲಿ ಒಟ್ಟು ಪರವಾಗಿ 300 ಅವರಿಗೆ ಆಸ್ತಿಗಳು ಮಂಜೂರಾಗಿ ಆಯ್ಕೆ ಮಾಡಬಹುದು ಅಂತ ಅದನ್ನು ಕೇಳಿದ್ದಾರೆ. ಸದರಿ ದಾಖಲೆಯನ್ನು ಕೋರ್ಟಿಗೆ ಹಾಜರುಪಡಿಸಲಿಕ್ಕೆಯೂ ನೆನಪಿಲ್ಲ. ಆಸ್ತಿಗಳಿಗೆ ಕಂದಾಯವನ್ನು 1ನೇ ಫೆಬ್ರವರಿ ಕುಟುಂಬದ ಆದಾಯದಿಂದ ನಾವು ಕಳೆದ ಸುಮಾರು 7-8 ವರ್ಷಗಳಿಂದ ವಾಸವಿದ್ದೇವೆ. ಕಳೆದ 8 ವರ್ಷದಿಂದ ನಾನು ಬೇರೆ ಉದ್ಯೋಗ ಮಾಡಿಕೊಂಡು ಜೀವನ ಮಾಡ್ತೀನಿ. ಈ ಯಾವ ಮೊದಲು ಹಿಸ್ಟ್ರಿಯ ಬಗ್ಗೆ ಬೇರೆ ಯಾವ ಕಂದಾಯ ಅಧಿಕಾರಿಗಳಿಗೆ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ದಾಖಲೆಗಳು ಒಂದೇ ಪ್ರತಿವಾದಿಗಳು ಸ್ವತಂತ್ರವಾಗಿ ಯಾವ ಆಸ್ತಿಗಳನ್ನು ಬಿಡುಗಡೆ ಮಾಡುತ್ತಾ ಇದ್ದರು ಸರಿ ಅವರು ಸ್ವಂತ ನೆಲದಲ್ಲಿ ಕಾಂಗ್ರೆಸ್ ಸಭೆಯನ್ನು ತಿಳಿಸಿ ಸಹ ಸ್ವಂತ ಹಣದಿಂದ ಕಟ್ಟಿದ್ದಾರೆ ಎಂದು ಕುಟುಂಬದಿಂದ ಹಣ ಕಟ್ಟಿಯಿಂದ ಕಟ್ಟಿದ್ದಾರೆ ಪುಣೆಯ ಮಂಡಳಿಯಿಂದ 300 ಅವರನ್ನು ಸುಮಾರು 23 ಎಕರೆ ಇದೆ ಅದು ಅಳತೆ ಆಗಿಲ್ಲ. 1995ರಲ್ಲಿ ಯಾವ ಆಸ್ತಿ ಮಂತ್ರಿಗಳಿಗೆ ಸುಮಾರು 25ರಿಂದ 50 ಈ ವರ್ಷ ಸದರಿ ಆಸ್ತಿಯ ಬೆಲೆ 1 ಲಕ್ಷ ರೂಪಾಯಿಗೆ ಒಂದು ಸಾರಿ ಕಳೆದ 8 ವರ್ಷದಿಂದ ಇಂಗ್ಲಿಷರಲ್ಲಿ ನಕರಾಗಿದೆ. One more witness has been examined that is been that particular person is Samapaya, Samayappa. And that particular person says that Anataman Level City Modi Kodha. Then I got the panel of people very clear. He says that rather than living together, he says that yes, they are living. So he was not aware when we have separated, when we are living, when we live together at all this time. So he is not a witness to you. My evidence starts at my lord, page number 37.
Page 37. Yes.
In paragraph 1, there is a mention in 4th line. There is a mention. Now, 3rd line. Now, 1964 ಹಿಂದಿನಿಂದಲೂ ವ್ಯವಸಾಯ ಮಾಡುತ್ತಿದ್ದೇವೆ. ನಾವು ಅಜ್ಜಪುರದಲ್ಲಿ ಕಾಯಂ ನಿವಾಸ ವಾಸವಿದ್ದೇವೆ. ನಾವು ನನ್ನ ಹೆಂಡತಿ ಮಕ್ಕಳು ಪ್ರತ್ಯೇಕವಾಗಿ ವಾಸ ಮಾಡುತ್ತೇವೆ. ನಾವು ಚಂದ್ರಶೇಖರಯ್ಯ ಎಂಬುವ ಮನೆಯಲ್ಲಿ ವಾಸ. ನನ್ನ ತಂದೆ ಮತ್ತು ವಾಗಿ ಶ್ರೀನಿವಾಸ ಪ್ರತ್ಯೇಕವಾಗಿ ವಾಸ. ಯಾವ ಆಸ್ತಿಗಳನ್ನು ನಾನೇ ಅನುಭವಿಸುತ್ತಾರೆ. ಮೊದಲೇ ಸತ್ತುಗಳು ಚಂದ್ರಶೇಖರಯ್ಯ ಸೇರಿವೆ. ನಾನು ಅವರಿಂದ ಏನಿಗೆ ಅನುಭವಿಸುತ್ತಾರೆ. 164 ಪುಣೆ ಮಂಡಳಿ ರಚನೆಯಾದಾಗ ಯಾವ ಆಸ್ತಿಗಳ ಬಗ್ಗೆ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಅನ್ನು ನಾನು ಅದನ್ನು ಫಾರ್ಮ್ ನಂಬರ್ 7 ಅನ್ನು B4 to B7 are one document. Then those are the earlier RTC. Then other documents. Totally, I have marked exhibit E83 method. Sorry, I have marked E86. Para 6 I would like to read because in this paragraph there is a reference to the exhibit. 6, page number 9. Page number 39, para 6.
The 6, yes.
ನನ್ನ ತಂದೆ 1980ರಲ್ಲಿ ಮರಣ ಹೊಂದಿದ್ದಾರೆ. ವಾದಿ ನೀಡಿದ ವಕೀಲರ ನೋಟಿಸ್ ನಾನು ಹೊರಗಿದ್ದೇನೆ. ಅದನ್ನು ಮತ್ತು ಅದರ ಕಚೇರಿಯನ್ನು ವಾದಿ 1964ಕ್ಕಿಂತ ಮೊದಲಿನಿಂದಲೂ ಬಿಡಿಯ ಸ್ಟಾಕ್ ಅನ್ನು ಬಿಟ್ಟುಕೊಂಡಿದ್ದಾರೆ. ಪುಣೆ ಮಂಡಳಿ ಮಂಜೂರಾದ ಯಾವ ಆಸ್ತಿ ಉತ್ಪನ್ನ ಸಹ ನಾನೇ ಪಡೆಯುತ್ತೇನೆ. ಪ್ಯಾನಲ್ ನಂಬರ್ 7. ನಾನು ಯಾವ ಆಸ್ತಿಗಳಿಗೆ ಒಂದು ಸ್ಲಾಟ್ ಎನ್ನುವರಿಗೆ ಮಾರಾಟ ಮಾಡಿದ್ದೇನೆ. ಅದು ಸರ್ವೆ ನಂಬರ್ 1993 1994ರಲ್ಲಿ ಮಾರಾಟ ಮಾಡಿದ್ದೇನೆ. ವಾಲ್ಗೂ ಸಹ
Sue property, one of the properties granted to you, you have sold.
ಮಾರಾಟ ವಾಲಿಗೂ ಸಹ ವಿಚಾರ ಗೊತ್ತಿದೆ. ಸದರಿ ಮಾರಾಟವನ್ನು ವಾಲಿ ವಿಷಯ ಮಾಡಿಲ್ಲ. ಸದರಿ ಕ್ರಯ ಪತ್ರದ ದೃಢೀಕೃತ ನಕಲನ್ನು ಹಾಜರುಪಡಿಸಿದೆ. ಇದನ್ನು ನಿಶಾನೆ ಡಿ 86 ಎಂದು ಗುರುತಿಸಿದ್ದಾರೆ. ಯಾವ ಆಸ್ತಿಗಳು ನನ್ನ ಆಸ್ತಿಗಳನ್ನು ತೀರ್ಮಾನಿಸಿ ವಾಲಿಯ ದಾವೆಯನ್ನು ವಜಾ ಮಾಡಿದೆ.
ಏನು ವೆಂಕಟರಾಮಯ್ಯ ನನ್ನ ಮಾವ ಅವರು ಮರಣ ಹೊಂದಿದ್ದಾರೆ. ಮಾವ ಅಂದ್ರೆ ಯಾರು? ವೆಂಕಟರಾಮಯ್ಯ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್. ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಹರೀಶ್, ಪ್ಯಾರಾಗ್ರಾಫ್ 9. ನನ್ನ ಮಾವ ಅಂದ್ರೆ ಅಲ್ಲಲ್ಲ, ವೆಂಕಟರಾಮಯ್ಯ ನನ್ನ ಮಾವ ಅವರು ಮರಣ ಹೊಂದಿದ್ದಾರೆ. ಅವರಿಗೆ 3 ಜನ ಗಂಡು ಮಕ್ಕಳು. ಸದರಿ ಅವರಿಗೆ 4ನೇ ಪ್ರತಿವಾದಿ ಚಂದ್ರಶೇಖರಯ್ಯ, ಕೇಶವಮೂರ್ತಿ ಹಾಗೂ ಶೇಷಣ್ಣ ಅವರು 3 ಜನ ಬದುಕಿದ್ದಾರೆ. ಸೊ ಈ ಪ್ರಾಪರ್ಟಿನೂ ನಿಮ್ಮ ಮಾವಂದೆ, ಟೆನೆಂಟ್ ಪ್ರಾಪರ್ಟೀಸ್. ಮಾವ ಅಂದ್ರೆ ಹೆಂಗೆ? ಇಸ್ ವೈಫ್ಸ್ ಫಾದರ್. ನನ್ನ ಮಾವ ಅಂದ್ರೆ ಏನಾಗಬೇಕು? ತಾಯಿ ತಮ್ಮನ? ಇಲ್ಲ ಇಲ್ಲ ಹೆಂಡತಿ ತಂದೆನ? ಇಂಟರ್ನಲ್ ಇದು ಡಿಕ್ಲರೇಷನ್ ಎಷ್ಟಿತ್ತು ಒಟ್ಟು ಅವ್ರಿಗೆ, ವೆಂಕಟರಾಮಯ್ಯ ಅವ್ರಿಗೆ ಜಮೀನು? ಅದಕ್ಕೆ ಸಂಬಂಧಿಕರನ್ನ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಹಾಕ್ಸಿರೋದನ್ನ. That is why, so that it stays in the family. But now family members are fighting for it. Yes. ಅಷ್ಟೇ, ಇದು ಯೋಗ ಇರ್ಬೇಕಲ್ಲ, ಇದನ್ನೆಲ್ಲ ಮಜಾ ಮಾಡಕ್ ಯೋಗ ಇರ್ಬೇಕು ಎಲ್ಲಾರ್ಗು. ಅಲ್ರಿ ಸರಿ ಪಾಪ, ಅವನ ಯಾರೋ ಶಿರಾಜ್ ಇದು ಬದುಕೊಂಡೆ, ಅವನ್ ಯಾಕೆ ತೊಂದ್ರೆ ಮಾಡಿ ತಗೊಂಡ ಸುಮ್ಮನೆ. No, there is no dispute. The land was registered in your name. There is no dispute. The only question is, have you showed that you are separate and you are not in any way connected with the family?
My submission is that it is the plaintiff who was required to discharge his bonus, so that it is a joint family. Also, when there is a grant, is in favor of loan. And when the revenue entry is
Let's read the cross examination.
Yes.
Written. Yes.
ನಾನು ಗ್ರಾಮ ಲೆಕ್ಕಿಗನಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೆ. ನಾನು 1972, 73, 4ನೇ ಸಾಲಿನಲ್ಲಿ ಗ್ರಾಮ ಲೆಕ್ಕಿಗನಾಗಿ ನನ್ನ ಕೆಲಸ ಸರಿಯಾಗಿ ಮಾಡುತ್ತಿಲ್ಲ ಅಂತ ನನ್ನ ತಂದೆ ಶಾಂತಗೌಡ ವೆಂಕಟೇಶಯ್ಯ ಮತ್ತು ವೆಂಕಟರಾಮಯ್ಯ
ವೆಂಕಟೇಶ ಮತ್ತು ವೆಂಕಟರಾಮಯ್ಯ ಭಾವ. ವೆಂಕಟೇಶಯ್ಯ ಯಾರು? ವೆಂಕಟೇಶಯ್ಯ ಮತ್ತು ವೆಂಕಟರಾಮಯ್ಯ ಭಾವ ಮತ್ತು ಮೈದುನ, ಅಂದ್ರೆ ಅದೇ ತಾಯಿ ತಮ್ಮನ. You are denying that very fact itself.
ನನ್ನ ಮದುವೆಯಾಗಿ ಇಲ್ಲಿ ಸುಮಾರು 25 ವರ್ಷ. ನನ್ನ ಮದುವೆಯವರೆಗೂ ನನ್ನ ತಂದೆ ಜೊತೆಯಲ್ಲಿದ್ದೆ. ನನ್ನ ಮದುವೆ ಆಗುವವರೆಗಿನ ನಾನು ನನ್ನ ತಂದೆ ಒಟ್ಟಿಗೆ ಸಾಕ್ಷಿಯಾಗಿರುತ್ತಾರೆ. ಮದುವೆಯಾದ ನಂತರ ಎಲ್ಲರೂ ಬೇರೆ ಆಗಿದ್ದಾರೆ. ನಾನು 1964 ಸುಮಾರು 8 ವರ್ಷ ಮೊದಲಿನಿಂದ ಯಾವ ಆಸ್ತಿಯಲ್ಲಿ ಕಾಣು ಮಾಡಿದೆ. ನನ್ನ ತಂದೆಗೆ ಯಾವುದೇ ಆಸ್ತಿ ಇಲ್ಲ, ಈಗಲೂ ಸರಿಯಿಲ್ಲ.
ಯಾವುದೋ ಆಸ್ತಿ ಇರಲಿಲ್ಲ.
ನನ್ನ ತಂದೆ ಶಾನುಭೋಗ ಕಾಲದಿಂದ ನಮ್ಮ ಆದಾಯದಿಂದ ಅವರ ಮಕ್ಕಳ ನಮ್ಮನ್ನೆಲ್ಲ ನಡೆಸಿದರು. ಆ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಮಕ್ಕಳು 7-8 ಜನ ಇದ್ದರು. ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ತಂದೆ ನಮ್ಮ ಕುಟುಂಬದ ಯಜಮಾನರಾಗಿ ಆನಂತರ ನಮ್ಮ ಕುಟುಂಬದ ಯಜಮಾನನಾಗಿ ಅನ್ನೋದು ಸರಿ.
ಆನಂತರ
ನಾನು ನಮ್ಮ ಕುಟುಂಬದ ಯಜಮಾನನಾಗಿದ್ದೆ ಅನ್ನೋದು ಸರಿಯಲ್ಲ. ಆದ್ರೆ ನಾನು ನನ್ನ ಹೆಂಡತಿ ಮಕ್ಕಳ ಕುಟುಂಬದ ಯಜಮಾನ.
So you set up a partition in the year 1954. No, 54. ಯಾಕರ 64 ಮುಂಚೆ 8 ವರ್ಷ ಅಂತೀರ. See, the deposition was recorded in the year 1998. We were, let us say, about 70 years. So if you go back 30 years, you were like 30 years. So you claim that you got separated when you were 20 years old.
Obviously, because early marriage and the number of children we had, and number of children my father had, it is obvious that I got married and separated.
And you were staying in your Mava's house, Venkataraman Manali 3.
ನಾವು ಜಮೀನನ್ನು ಸಾಲು ಮಾಡಲು ಪ್ರಾರಂಭ ಮಾಡಿದಾಗ ಅದರ ಸಹೋದರರು ಚಿಕ್ಕವರಾಗಿದ್ದಾರೆ. ಆದರೆ ಅವರು ಬೇರೆಯಾಗಿ ನನ್ನ ಹೆಂಡತಿ ಮತ್ತು ಮಕ್ಕಳ ಜೊತೆ ಬೇರೆ ನಾವು 4ನೇ ಪ್ರತಿವಾದಿ ಚಂದ್ರಶೇಖರಯ್ಯವರ ಮನೆಯಲ್ಲಿ ವಾಸ. ಸತಿಯವರು ಬೆಂಗಳೂರಿಗೆ ಹೋಗಿ ಸುಮಾರು 4 ವರ್ಷ ಆಯಿತು. ಸತಿಯವರ ಅನುಮತಿಯ ಮೇರೆಗೆ ಮನೆಯಲ್ಲಿ ಇಲ್ಲೇ ವಾಸವಾಗಿ
ನಿಮ್ಗೆ ಕೊಟ್ಟೋದ್ರ? ಜಮೀನು ಕೊಟ್ಟರು, ಮನೇನು ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ?
4ನೇ ಪ್ರತಿವಾದಿ ಇನ್ನೂ ಜೀವನ ಮಾಡಿದ್ದಾರೆ. very common.
That they would give out 26 acres in favor of.
Same thing has happened with so many families, including in my family. We have left our village long back, and we have left our.
We have also left our village. We also know that, but this kind of. Continue to move. We started now. Let us start.
Isn't that my lord?
He will come. Don't worry. Tomorrow. ಏನಾಗಲ್ಲ. ಅವ್ರು ಬಂದ್ರೆ ಇನ್ನೂ ಇಷ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಬಿಡ್ತಿರ್ಲಿಲ್ಲ ನಾನು. ನೀವಾಗಿದ್ದು ಸುಮ್ಮನೆ ಬಿಟ್ಟಿದ್ದೀನಿ ನಾನು ಇಷ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ. Tomorrow. It's a 2006 matter. Ask Mr. Tomorrow, let him come tomorrow.
ಅದೆಲ್ಲ ಒಂದು 5 ವರ್ಷ ಮುಂಚೆ ಇಲ್ಲ 19 ನಾವು ಒಂದು 5 ವರ್ಷಕ್ಕೆ ಒಟ್ಟಿಗೆ
ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದೀರಾ?
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಬರುತ್ತೆ ಸರ್.
ನೆಕ್ಸ್ಟ್ ಮಂತ್. ಥ್ಯಾಂಕ್ ಯು.
Final hearing not reached matter, sir. Court officer.
Next Monday ಬರುತ್ತೆ.
ಎಲ್ಲ next Monday.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದು ಲಿಸ್ಟ್ 3 ಅಲ್ಲಿ ಒಂದೇ ಆದದ್ದ ಫಸ್ಟ್ ಮಾತ್ರ ಮ್ಯಾಟರ್ ಆದದ್ದ ಲಿಸ್ಟ್ 3 ಅಲ್ಲಿ
ಸರ್ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಬರುತ್ತೆ ಸರ್.
ಒಂದೇ ಮ್ಯಾಟರ್ ಆದಲ್ಲ ಅದರಲ್ಲಿ?
ಹೌದೌದು, ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಮಾತ್ರ
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಬರ್ತದಲ್ಲ ಬ್ಯಾಲೆನ್ಸ್ ಅಲ್ಲಿ.
ಹೌದೌದು.
ಥ್ಯಾಂಕ್ ಯು.